of the surrender date, my lord. My lord, the date is fixed to second, my lord. May I pray for?
Lordship, 4:30 tied up.
Pardon, my lord, modification of order.
2-3 times I have mentioned your lordship.
The lordship in this Anganwadi matter wherein the government guideline is very clear, which says that within the 2 days the petitioner will get an appointment letter, but they did not give for that reason argument to both the matters.
Yes,
Madam, the argument note which I am submitting, judgment was written.
That's second appeal.
Second.
Yes.
May I be permitted to make a mention, my lords?
Yes.
My lords, this is ABLAPL 3102 of 24. It's a tired of matter. 1 month have elapsed. I have made a mention. May I pray any day this week?
Give a memo.
Yes, memo I will send for them, my lords, physically.
My lord, may I mention BAPL number 2517 of 2024? My lord, of last date of hearing, my lord was directed to list this matter on week commencing 29th April. But in the weekly list, the matter is not listed, my lord.
File a
The-
memo.
Please, my lord.
Yes. Supplement list item number 1, press admission.
Praise the Lord.
Yes.
My lord, petitioner is the husband, my lord. Both are of permanent resident of Bargod, my lord. Marriage took place at Bargod in the year 2013, my lord. Since 2018, they are separated. In 2020, petitioner has filed a divorce case before the Judge Family Court, Bargod. And in that case, she has filed a petition under section 24 of the Hindu Marriage Act, interim maintenance also award. Now, my lord, that case is also pending. Now she has filed a TR 125 proceeding before the Judge Family Court, Bhubaneswar, my lord. So I pray, my lord, for file application for transfer of the case from Judge Family Court, Bhubaneswar to Judge Family Court, Bargod, where the MAT case is also pending. He has also got interim maintenance, my lord.
Where is she residing?
Residing, my lord, permanent resident, Bargod. Marriage took place and in Bargod.
No. Where is she residing at present now?
At present, my lord, she has given that Khandagiri, my lord. He has in her petition.
It would be difficult. It would be inconvenient for her to come to Bargod.
Bargod is that other case and execution case is pending, my lord.
Yes.
Main case, my lord, and execution award has
Main case filed by you.
Yes, my lord, and 124 lordship down to page, my lord. 19 annexure 4. Interim maintenance was also awarded. 15,000 per month.
That is besides the point. The question is who has filed the divorce petition?
Petitioner, my lord.
You have filed where? As Bargod.
Bargod. Both have a permanent resident of Bargod.
No. You don't go to the other facts. So now what other petition has she filed at Bargod?
Execution case, my lord. And award is also in
execution of what? Which order?
Interim maintenance award in that MAT case.
In the divorce case?
Divorce case, my lord. That is section 24. That order has been passed.
All right, take notice. Issue notice to the opposite party by speed post, fixing a short returnable date. Requisites be filed by tomorrow. List this matter on 14th May 2024. In the meantime, if any application for adjournment is moved on behalf of the petitioner in the court below, the same shall be considered, having regard to the date fixed for hearing of this case. Yes.
Right now, we have just family court for Bhubaneswar. Because that case is 125 proceeding is before Judge Family Court, Bhubaneswar.
So I've said court below. Yes.
Petitioner is the wife. Opposite party is the husband.
Yes.
Husband has instituted a divorce proceeding at Kendrapada. Petitioner is now residing at Ganjam within the jurisdiction of Civil Judge Senior Division Aska. So I am paying for transfer of CP divorce proceeding from Kendrapada Family Judge to Sub Judge.
On what ground? That she is residing at.
Yes.
All right. Take notice. Issue notice to the opposite party by the speed post, fixing a short returnable date. Requisites be filed by tomorrow. List this matter on 14th May. In the meantime, if any application for adjournment is moved on behalf of the petitioner in the court below, the same shall be considered, having regard to the date fixed for hearing of this case. Yes.
Hon'Ble.
Note 3. May I please, Judge? My lord, if petitioner is the deserted wife and the divorce case has been filed by the OP husband at Athagad, and the petitioner having the 2 years girl child and residing in Talcher. So, and also she has filed a case for maintenance in Talcher. And
You want the proceeding to be transferred from Athagad to Talcher?
my lord.
Well, take notice, issue notice by speed post, fixing a short returnable date, request to be filed by tomorrow. List this matter on 14th May. In the meantime, if any application for adjournment is moved on behalf of the petitioner in the court below, the same shall be considered, having regard to the date fixed for hearing of this case. Yes.
Item number 4.
May. So this is regarding consideration of the grievance of the petitioner for the appointment for the post of Jogana Sahayaka from salesman. The present petitioner is working since 2007 as a salesman. In 2012, government issued a notification under Annex 2 describing certain procedures and guidelines for appointment of Jogana Sahayaka.
You were working as original
Salesman.
salesman. Okay.
Yes, ma'am.
Okay.
In page 13, if you also will peruse, then the guideline, the criteria was fixed that the qualification of the candidate should be +3 and he should be aged between 21 to 35 years. Thereafter, subsequently, Annex 3 was issued in 2013, modifying that guideline in respect of 8 KVK districts, wherein the qualification was reduced to 10th pass and age relaxation was allowed. And apart from that, my lord, after issuance of
Age
this,
relaxation kotha koha raha
my lord,
hai? Age relaxation has
but, it is there, my lord. Subsequently, this notification was made applicable to other districts.
no, that's all right. But where is the age? Age
It is
relaxation
not mentioned, but the collector issued a notification in the 8 KVK district in relaxation of age. That notification is not with
How could
me.
you do that? How could you do that without the approval of the government? Anyway, so
Thereafter,
further
the
section-
petitioner approached, petitioner is a disabled person, so he approached the authority concerned as disability commission, my lord. And disability commission,
So what is the method of appointment? Let us see.
method of appointment, your lordship,
Procedure for appointment.
Annex 2, my lord.
Annex of
This
2,
is
page
guideline.
13, read clause 5.
Yes,
The GP shall make a resolution in
procedure
the
for appointment of Jogana Sahayaka by GPs. The GPs shall make a resolution instructing to appoint the Jogana Sahayaka if they are dealing with at least 150 quintal of PDS items in a month. The resolution also indicate the amount of honorarium for Jogana Sahayaka between 3,500 to 4,000. This resolution shall be sent to their BDO. The BDO shall collect all such resolutions from the GPs and make a common advertisement inviting applications from the interested candidates. The eligibility conditions.
Was there any common advertisement?
No.
So,
Direction has been issued by the collector to make a common advertisement, but since the GP has passed a resolution that since the present petitioner has been continuing since 2007, his case be considered for appointment of Jogana Sahayaka.
on what basis?
For that reason, the notification.
On what basis? On what basis? The provision is there. What is the provision is that a resolution and to make a common advertisement inviting applications from interested candidates.
Yes.
Salesmen are also entitled to be given preference.
But
as per
in
the
view of
notification.
this guideline, my lord,
Further, the salesman engaged by Gram Panchayat for dealing with PDS may be given preference over others due to their experience in the job.
but
So
the,
wait. So this does not mean that the need for advertisement is done away with. It has to be an advertisement, open advertisement. So there was there any
if the advertisement will be issued in pursuance to this guideline, my lord, then I will be debarred to participate in the notification
Well-
because here the qualification has been prescribed +3 and the age criteria is 21 to 35 years.
No, but that has to be read along with this 12/8/2013, whereby the you belong to a tribal district.
No, ma'am. I belong to Barampur district, Ganjam district.
So
My humble submission before lordship, the Annex 3 has been made applicable to all other districts subsequently.
All right.
By the notification.
then you will be benefited by it. So that is a 10th class.
Yes, but they are not reducing
What
the
they are not reducing?
qualification as well as the age.
So where is the cause of action? Where is the advertisement? Where is the advertisement?
No advertisement is issued in view of the resolution passed by the GP.
No, the GP cannot simply pass a resolution to appoint somebody as Jogana Sahayaka. It has to be by way of an advertisement.
But unless
Yes,
and until,
you being a salesman, you can be given preference. That's
but
all.
unless and until a resolution is passed by the GP,
Maybe, but
notification
resolution-
cannot be issued. For that
Resolution-
reason, I have submitted my grievance with
No,
the opposite
what
party number
grievance?
1.
No, what grievance? Unless a advertisement comes out
Then will also may permit me to file an additional affidavit enclosing the resolution filed by the GP.
You may, but what of what to what avail? To what avail? Only a resolution of the Gram Panchayat without consequential advertisement. It has got no meaning.
No, in the guideline, it has been mentioned that unless a resolution is being made.
Let us
GP
come to the guideline again.
Yes.
Let us come to the guideline. That is why I asked you to read clause
Yes,
5.
Clause 5, my lord.
What does it
The
say?
GP shall make a resolution in
Yes.
their meeting to
Yes.
appoint a Jogana Sohayaka if they are dealing with.
This resolution shall be sent to the
Yes.
BDO. The BDO shall
On
collect
advertisement.
all such resolutions from the Gram Panchayats
Yes,
and make a common advertisement.
yes. But
The first part has been done.
in any case, the GP has passed a resolution that since the present petitioner has been continuing since 2007 as a salesman, so there is no requirement for appointment of a fresh Jogana Sohayaka. Instead of appointment of a fresh Jogana Sohayaka, the present petitioner's
No.
case be considered for
No,
appointment in that.
That will be contrary to the guidelines. That is clearly contrary to the guidelines, Mr. Panda. Whatever you have read out, clause 5, it says something, we are claiming something else. So every Gram Panchayat has to pass a resolution saying that Jogana Sohayaka is needs to be appointed. Then it has to be sent to the BDO. The BDO will collect all such resolutions from the Gram Panchayats and then make a common advertisement.
But unless the
In that common advertisement, you can be an applicant pursuant to such a, and you may be given
to
preference.
condition that I got the eligibility, I fulfill the eligibility criteria. Because eligibility
Your cause
criteria.
of action, there is no cause of action for this writ application. There is no cause of action. Let us see what is your prayer. Direct to consider the grievance of the petitioner. No. Your grievance itself is not valid. It's not tenable in the eye of law.
Then I may be permitted to brought the GP resolution.
You may, but what will it, how will it
Then
help
the
you?
lordship may observe in that regard, dispose of the writ petition, observing that unless a GP resolution is passed.
No, not only a GP resolution. You say that a GP resolution has been passed,
Yes,
but it has to be followed by an advertisement.
but GP resolution has not been passed for a appointment of advertisement, but it has been passed to consider the case of the petitioner for that.
It cannot be done because you have yourself enclosed the notification. The notification says something else. There's a different procedure altogether.
I cannot avoid my law because this is government notification.
So-
For that reason, I have a.
So clause 5 lays down the procedure.
Yes,
There cannot be direct appointment of a salesman as Jogana Sohayaka. There is no such thing. You may be given preference. That's all.
that
You
will
may be given
also
preference.
that if a GP resolution is passed for appointment of Jogana Sohayaka and a notification is issued, then I may be allowed to participate at least in the selection because
No.
the
No,
guideline says. the
You don't need an order
qualification-
for that. You don't need an order for that.
Because the guideline says well, the qualification of +3 and age is in between 21 to 35, whereas now I am of the age of 45 years perhaps.
The prayer itself is not tenable.
That is 48 years.
How many of
So I cannot be participated.
No. This will not, no. There is absolutely, this will be completely contrary to the notification which you have yourself
For
enclosed.
that reason, I am submitting that let me file the GP resolution with.
You may file. I can record your submission. I can also record your submission that according to the petitioner, the resolution was passed, such and such.
Then your lordship may dispose of the writ petition by observing that in case the notification is issued for appointment of Jogana Sohayaka, I may be permitted to participate. in this.
No. Without the other,
Otherwise, my lord, if a Jogana Sohayaka will be appointed, then I will lose my job.
no, why? You will continue as the salesman
No, my lord, because Jogana Sohayaka will be appointed.
in
for
place of salesman.
Yes, for distribution of PDS.
That's a different, that's a completely apprehended cause of
Since
action.
2007,
step-
I am working.
Mr. Panda, no steps have been taken at all. And what you are
In
saying,
view of the GP resolution, no steps has been taken.
no steps have been taken. So you are continuing, you continue. Why are you coming forward with this is a preemptive application. This is a completely preemptive application. There is not, you see, unless there is an advertisement, and unless you have been debarred from appearing, submitting your application on the ground of overage, which you say is no longer valid because the collector has passed some order or the government has passed some order,
Yes.
inclusing making it applicable to all the districts.
Yes.
It's in Annex 3, there is no mention of age. It simply says educational qualification may be relaxed.
Educational qualification.
And it will be let us
relaxation has been
class past equivalent to matriculation.
given. Age relaxation has been given, but that is no notice.
Nice. So where is that? Where is that? Where is that?
Let me inquire about that and I'll file that.
କିଛି ନାହିଁ କାହିଁକି ରଖିବେ ହବନି
ନା ମୁଁ ଟିକେ ଦେଖେ ଯଦି ସେଇଟା
କାହିଁକି ଦେଖିବେ ଆପଣ
So age relaxation,
Open
I will get a chance.
declare them
I will get a chance to participate in the.
No, it is open to you. It is open to you. If you fulfill the criteria, it is open to you. I can make that
In view
observation.
of the guideline, I may not fulfill the criteria. I will also.
সেটা তো কথা, সেটি তো কথা।
Qualification is there and the age criteria is there.
How can this, you can get a order from the court, blanket order that you will be allowed to participate? When this court, right now cannot be satisfied that you have fulfilled the criteria.
Otherwise, my lord, in case a notification is issued, then certainly I will lose my job.
So nothing can be done about it. Nothing can be done about it. You can only be an applicant, and if you say that the age criteria has been relaxed,
And for that reason, the GP has passed the resolution to consider my case for the post of Jogana Sohaka instead of appointing.
GP has no power to do that. GP has no power to do that.
In view of the guideline.
In view of the guideline, that is a completely wrong interpretation of the guideline. The guideline says something, the GP has passed a resolution. What, I have not seen that resolution, but you say
The
that
resolution is with me.
you have been recommended to become the Jogan Sohaka. So they will override the guidelines of the government. The Gram Panchayat, no, they cannot. So, Havan, all you can do is, whenever the advertisement comes, you may submit your application. If you are eligible, then you will be considered, that's all. Yes, Mr.
Yes, madam. The annexure 3 that my learned friend has annexed
Yes,
doesn't refer to the district of Ganjam. All these 5
KBK
petitioners are-
districts, only KBK.
That I have stated
Yes.
that in my read petition also I have mentioned that subsequently it has been made applicable to all the districts.
Where is the document?
That document I will file.
আজ
document
ଆଉ
already-
adjourn ତ ହବନି ଆଉ ସରିଲା ଏଠି ଆଉ।
Then your lordship may dispose of in that light that if a notification is issued.
That also, no.
I may participate. If I fulfill the criteria, then I will be my case will be considered in case of other, with the other applicants.
In view of your own admission that you are you do not have the age.
Yes.
Number one. Number
Age
two,
and qualification.
qualification is you are 10th class,
Yes.
but the qualification required is +3.
Plus.
It has been relaxed only in respect of KBK districts.
But
You do
subsequently.
not belong to the KBK district.
No, subsequently it has been made applicable to all districts.
Where is that
That I have stated in my read petition.
No, you may have stated it, but where is the document?
Document is there, but at the time of filing of the read petition, that document was not with me. So if your lordship will permit me, that I can file that document.
Yes,
That
but you say-
document is there.
as your lordship would direct.
There is no use keeping it pending. It will not help him in any manner. The order that I am going
At
to pass
present,
today
it appears to be premature.
is absolutely premature and without any cause of action, without a definite cause of action. You let us come to a prayer. Whatever you are praying is something very outlandish. You say consider the grievance of the petitioner, appoint him as Jogana Sohaka Vikari Poli. Kimdi? How can direction mandamus be issued directing the authorities to appoint you as Jogana Sohaka, bypassing the notification, the rule guidelines?
No, only I pray that in case an advertisement is issued, then I will participate if I will fulfill the criteria, then my case be considered along with the other applicants.
All right. The petitioner has approached this court seeking the following relief.
Petitioners,
Petitioners.
No,
batch of
there are other reports.
ନାଇଁ ଗୋଟେ କରିଦଉଛି ସେଥିରେ
Yes.
This court finds that as per notification of the government dated 21/4/2012 in Food Supplies and Consumer Welfare Department, a procedure for appointment of Jogan Sohaks by Gram Panchayats has been laid down under clause 5 thereof. Stop. As for the said clause, the Gram Panchayats are required to make a resolution in their meeting to appoint a Jogan Sohak on fulfillment of certain conditions. Stop. Such a resolution is to be sent to the BDO, who is to collect all such resolutions from Gram Panchayats and make a common advertisement inviting applications from interested candidates. Stop. Further, the eligibility conditions have also been enumerated under clause 5. Stop. In course of hearing, in a query posed by the court, learned counsel for the petitioner fairly admits that till date, no advertisement has been issued. Though no advertisement has been issued. So, in such view of the matter, the approach of the petitioner to this court at this stage appears to be premature. The writ application is therefore disposed of with the observation that in case an advertisement in terms of clause 5 of notification dated 21/4/2012 is issued, the petitioner may submit his application if he fulfills the eligibility criteria as laid down in the said guidelines. Stop. Writ application is disposed of accordingly. Yes.
In view of the said guideline and subsequent guidelines if issued by the government.
Yeah, that will take
The
care.
relaxation has been issued.
And guidelines and any subsequent guidelines
Ma'am.
/ instructions issued by the government
Ma'am.
in this context. Yes. So what are same? All
Yes,
these matters
yes.
are same.
Yes.
All right.
Item number 5.
I have filed 2 affidavits. I have served copy on, the state is the only correspondent. Here not very interesting, the suit was very, suit filed, I am the plaintiff. Suit was filed by the plaintiff saying that the property belongs to my ancestors and I had inherited it, recorded in my name, but presently it has been wrongly recorded in the name of the state government. Accordingly, declaration of rights lapsed. State did not contest. It was ex parte. But in ex parte, it was found that this property was acquired by the state government for the southeastern railway. Now, this acquisition was subsequently withdrawn under section 6A. The courts below have proceeded on the footing that I have failed to establish any material showing that the property belonged to my ancestors. So this main point before your lordship asked is, since the state government has issued land acquisition proceeding, it presupposes that I am the owner of the land. That is 2003 Supreme Court, your lordship must have known that, saying that state cannot acquire its own land. It is only private land. So once state has moved for acquisition, it presupposes that it was my land and they had to acquire and subsequently they withdrew from it. This is the main point urged before.
So the suit was for declaration of title. All right.
And they did not contest.
So what was the finding of the trial court?
That no material was there to show that it belonged to my ancestors.
So on evidence, there was no evidence according to the trial court.
My averments were there, my evidence was there, uncontroverted.
So what about the lower appellate court?
Same, ditto.
Can we see the judgment, please?
Yes, Lord. Your lordship may see.
Trial court judgment, let us first.
Yes, trial court judgment, your lordship.
You are Dhaneshwar Gowda, Maneswar Gowda and Jogeshwar Gowda, the plaintiffs.
Yes, plaintiffs. The scheduled tribe persons who have paragraph 5, your lordship.
Paragraph 5.
What you got?
Just paragraph
Perhaps page 5 of the
page 5. Okay. Paragraph 5, yes.
5. This suit has been filed by the plaintiffs being indigent persons for declaration of the right title interest for confirmation position, alternative recovery position in respect of suit. From the evidence of PW1 and pleadings of plaintiffs, it appears that suit land appertains to Sabi Khata number so and so measuring it. In different settlement records, the note of forcible position has been noted in favor of the ancestors of plaintiffs, namely so and so, widow of Lakshman Gowda, and subsequently in the name of Nathu Gowda. But the record of rights have been prepared in the name of state, showing this suit land as Anavadhi. Further, it reveals that one Nathu Gowda is the original ancestor of the plaintiff. This is Bantu Gowda, died leaving behind his widow Surajmani Gowda and 3 sons Lakshman, Sudam and Shiva. Sudam and Shiva, both of them died issueless. Lakshman died leaving behind his widow Surajmani and his only son Bhagavatia. This is Bhagavatia died leaving behind his mother Surajmani Gowda and his 2 minor sons Nathu Gowda. Surajmani, wife of Lakshman, died in the year 69. Nathu died in the year 86, leaving behind him the plaintiffs and his brothers. Khatu died in the year 2003, we expressed. But during the lifetime of Khatu, he had applied 3 mutation cases so and so in the ROR in respect of Suitland, but those mutation cases have been dismissed as by the order of the learned Tahsildar. Further, PW1 states that Suitland was originally the royalty land of the ancestors, but it had been recorded in the name of state through their ancestors and themselves had in continuous possession in respect of Suitland. This is important. On close scrutinization of the documents filed by the plaintiffs, it reveals that the evidence of the plaintiff provided the pleadings of the plaintiffs are totally inconsistent with the documents which earmarks Exhibit 2 and 3 and the Xerox copy of notification dated so and so. This is the additional evidence which I have produced, the certified original of the notification, which was taken note of, but it was not exhibited. That's why I have produced before. The Xerox copy of notification so and so services shows, whereas by notification of the government of Orissa and Revenue Department so and so dated as subsequently corrected, certain lands were notified to be acquired under Section 3 of the Orissa Development, Agriculture, Capital, Resettlement, Displaced Person, Land Acquisition Act 1948. And whereas out of the said land so notified, certain portions of the same as specified in the schedule below are no longer required for the state government and in respect of which no position has been taken. Now, in exercise of the power conferred under 6A of the said act, the said government will hereby withdraw from the acquisition made right. Now, the property, the suit properties are there.
Yes.
29, 30.
So that notification was withdrawn.
Yes. So my submission before your lordship is the very fact they went for acquisition, it means the government cannot acquire its own land. It has to acquire my private land. So there was no, and particularly when there was no opposition from the end, there is no case made out by them. These two documents.
Now, did the state not file a written statement?
No, did not file written statement, did not contest. These two documents, which have been taken note of also by the lower appellate court, same with lower appellate court, I have filed a petition for additional evidence.
Yes.
Before your lordship. Now, this was the main question raised when the earlier matter came up earlier, and two other points which I have raised is that this courts below say that Southeastern Railway is a necessary party. My humble submission is it was acquired for Southeastern for the purpose of Southeastern, but it was withdrawn. So Southeastern it remains the state government's property. Southeastern Railway doesn't come into picture.
What is this? The last order,
Well,
Honorable Justice D. Das has passed this and comes for the appellants
these two notifications.
to go through the notification under Section 3 of the Orissa Development and Industry so and so, and the subsequent notification under 6A of the Act
6A.
as regards withdrawal of the state fund.
Yes.
But it is a fait accompli. It has already been withdrawn.
Both, yes.
So how is
That
it
is-
relevant now? That is what we have to.
For the purpose of record.
No, that's all right. But I'm asking in the sense that what did the court below see? Why did the court below think it to be relevant?
That is what I'm saying. That is the error. No, the question is 2003 Supreme Court, if your lordship sees, I'm sorry, I couldn't get the.
That's all right.
The state government cannot acquire its state government's property. It has to be a private property to be acquired.
No, you have filed a Order 47 rule.
Order
41 rule
27 petition,
Yes.
IA 496 of 24.
So let it lie over. We'll finally allow it
Type
at the time of final
hearing.
hearing. And this matter, I think this can be disposed of.
Yes, state
You
is
have
the
not,
only party. If I can solve the copies of,
Yes.
if they can get ready, that's.
At present, at the order 41 rule 11 stage, I have no
No,
right to contest.
Obviously not. Obviously not. I'll fix a date after vacation. We can finish. So let us frame the substantial question of law. What could be the question? Have you framed it, sir?
Yes, Lord.
A, B, C, D.
Page 7. Page 7, 2,
Page 7-2.
ground number 2
It is page 7, Ray.
of the appeal verb.
Appeal memo, it is A in para 14 of the plaint. Probably then page number is something.
My appeal memo.
Second appeal.
Yes, Lord. Ground A, B, ground B 2.
I think C would be more relevant. The courts below have completely ignored the documents, isn't it?
Yes, bro. That is that. That is that.
That I think.
And land acquisition, because as per 2003 Supreme Court. That is. Because once they go for acquisition, it means that
Not a government land.
not a government.
So that withdrawal of that notification is relevant.
So
Why
I will-
was it?
That we will consider at the time of final,
Yes.
we'll admit it before just this notification is of the government will have no objection, obviously.
Yes.
I can allow it right now, but I think normally
At the time of hearing.
at the time of hearing. So
Usually that is done.
you have the grounds you have said that we can take up as substantial question of law, mainly ground number 4. Ground number 4 and ground number 2.
As you know. 3, because this, it says there is no material. I have produced materials, they have not denied it. This 3. I have specifically pleaded, I have specifically led evidence, I have given exhibits 4 and 5, the earlier RORs, and that has not been controverted by them.
We can say whether the uncontroverted pleadings and evidence adduced by the plaintiffs, whether the court below was justified in ignoring it. That's one.
Right.
And second is that this notification,
Landing.
that is very important. All right. Heard Sri Ramakanta Mahathi, learned senior counsel with
Yes, Marty.
with Sri Esmanti, counsel for the appellants, sorry. After hearing learned senior counsel and upon perusal of the impugned judgments, the second appeal is admitted on the following substantial questions of law. 1, whether it was whether the courts below committed an illegality in not accepting the uncontroverted pleadings and evidence adduced by the plaintiffs in support of their case. Next, whether the courts below were correct in dismissing the suit. Non-jointer কথা নেই, সে যে withdrawal টা,
Withdraw.
whether the courts below
That is 4.
সেটা তো খালি non-jointer করে দিয়েছে, non-jointer
Non-jointed 2.
the effect, we want to see the effect of notification.
Yes.
Whether the courts below were correct in not considering the effect of withdrawal of the notification for land acquisition under section 6 capital A of the Land Acquisition Act.
No, that set out a border net. I'm giving.
ସେ ଯୋଉ land acquisition ନୂଆ act ଟା ତ
ନାଇଁ ନାଇଁ ତାଙ୍କର particular act.
ଓଇ ସେ ଯୋଉ railway ର
Railway କହିଥିଲି.
act, as the land was no longer required for the purpose of the proposed acquisition. That's all.
And they have also utilized this non-joinder. So non-joinder is also wrong in law because railway has not come into the picture.
But non-jointer we can consider otherwise also. Hala. Learned AGA accepts notice for the respondent. Let a copy of the appeal memo be served upon him within 3 working days. Stop. Call for the LCR. କାହାର ଭଲ ଛଡେଇକି ରଖିଲି ଯଦି କଣ call for the LCR, list this matter. What vacation per will fix a date.
We commencing sir 1st July.
Week commencing 1st July. IRA 496 of 2024. Let a copy of the IA be served upon learned State Council, who may file his objection, if any. The IA shall be considered at the time of hearing of the appeal.
I have also filed another because both the courts below status quo order was present. And that is.
Is there any? Why is there any? What is the cause of action? Is there any?
The state will now take over that is. I have quoted the order also. It came up to this honorable court. The honorable court also passed the order. This honorable court.
Where have you quoted it?
That is IA 350.
All right. Considering the submissions, status quo with regard to the possession over the suit land as on date shall be maintained till the next date.
Item number 6.
As on date shall be maintained till disposal of the appeal. स्टेट तो ये
State, खाली only state.
But we have served an affidavit dated 25 today only.
you have
They have served a copy of the affidavit pursuant to my lord's order today. Aji dele na? Aji file karo.
so that interesting.
Yes, sir. They are also filing it before my lords today only.
But Mr. Raiguru, you could have filed it earlier.
Well, there is
Unnecessary
nothing,
return.
but what was there in the counter of it, that is also reiterated, otherwise.
But anyway, if you, whenever you file a counter, it is his duty to bring it to the notice of his client.
But actually, it will not be tagged with the file, court file. A scan
आपने कॉपी टाइप कर दी थी आपने कोर्ट फाइल करिए चलिए it doesn't matter
I have also seen this.
as directed.
Now the point boils down to very limited question. Let's may take it up sometime next week.
Next week, next Wednesday, next Tuesday.
हाँ.
Tuesday हो तो
That can be disposed of.
14 में हो अच्छा.
We'll-
Sri Raiguru Learned Counsel appearing for the opposite party numbers 3 and 4 files an affidavit as directed in court. After serving copy on the other side, let's this matter on 14th May. Parties are requested to come ready for final disposal.
Interim order.
Interim order to continue.
Item number 7.
My plea, Your Lordship. Honorable Lordship, turn to the prayer first. Prayer made in the writ application, my lord. Prayers are twofold, my lord. To quash advertisement on Annexure 6 and to consider the case of the petitioner for appointment to the post of junior Hindi translator as per advertisement on Annexure 1. So for Annexure 6 is concerned, that has already been given effect to except the post of assistant Hindi because of the interim order was there. So far as Annexure 1 is concerned, my lord, that has already been cancelled, my lord. Because Annexure 1 was published on 34/2011.
Annexure 1.
One post was there, junior Hindi translator.
Yes.
5 persons, including the petitioner, have been shortlisted. They called to the appear the written test and subsequent interview. But on the date fixed for a written test, only one candidate petitioner, none other than arrived, my lord. Because of that, the selection committee took a decision to cancel the advertisement, and accordingly that was cancelled. That was intimated to the petitioner subsequently, and that was also not challenged. So far as the prayer person is concerned, to consider his case on the basis of Annexure 1 no longer survives. So for Annexure 6 is concerned, that has already been given effect to except the post of assistant Hindi. Now, during the pendency of this writ application, my lord, Niger has moved the government, Atomic Energy, to publish a post of, to create a post of junior Hindi translator, and which was, your lordship will find page 5, Annexure A/2 of the additional affidavit.
A/2. Hindi रे लिखा है. This is in Hindi.
राष्ट्रीय विज्ञान संस्था एवं अनुसंधान संस्थान भुवनेश्वर कृपया अपने दिनांक 10/8/2021 के पत्रांक संख्या सच का संदर्भ ले, जिसके माध्यम से नाइजर भुवनेश्वर ने कनिष्ठ हिंदी अनुवादक लेवल 6 के पद के सूचना के प्रस्ताव
सृजन
अनुमोदन
सृजन माने क्रिएशन
भेजा गया था
के
विभाग ने
के अनुमोदनार्थ भेजा गया है फॉर approval for to create a post.
To create a post. And second paragraph.
So that was in 2022.
Yes, that was created.
It was created.
That was created.
They have said so.
Paragraph 2.
शिक्षण पदाधिकारी ने उपयुक्त पुस्तक के लिए अपना अनुमोदन प्रदान कर दिया है. तदनुसार कनिष्ठ हिंदी अनुवादक का एक पद सृजित कर दिया गया है. तब
And as per your lordship may turn to my lord, page 11, my lord.
Page 11 of the brief
of the counter, my lord.
Of the counter.
Minutes of the meeting.
Which page 11? There is no page 11 in minutes of the meeting, annexure A. Isn't it? Minutes of the meeting though, on 10/9/2011.
10/9/2011.
10/9?
2011.
Yes,
Yes, minutes of the meeting
Hmm.
of the selection committee. Paragraph 2.
that is prior to creation of the post.
Try to create up the post. The committee has also, while cancelling the advertisement on Annexure 1, this decision was taken. The committee has also recommended that in future, wherever the recruitment process for junior Hindi translator will be initiated, the candidate Mr. Manas Ranjan Tripathi should be called for appearing in the test public interview. That has not been published. It was created in 2022. We have not published any advertisement for the post of junior. As and when it will be published, he will be called for. Irrespective of his age.
Two things, my lord. In my lord's brief, is there is a page 11 is there?
No, that is
I
page
don't
10.
know, he has relied
That is
on.
page 10.
Oh,
That's page 10. Sir.
no, sir.
Yeah.
ମୁଁ ଖୋଜୁଥିଲି ଆପଣ ଯୋଉଟା କହୁଛନ୍ତି।
ଆପଣ ବି annex କରିଛନ୍ତି ସେଟା।
ମୁଁ ଯୋଉଟା କରିଥାଏ ଆପଣଙ୍କର page 11 I am searching, sir.
Right.
Sir, I am putting a question to myself. The advertisement was put by the Niger. How can the selection committee will cancel that, my lord? It is the authority that the Niger to take a decision. If nobody turned up or less number of persons turned up, the matter was to be referred to the Niger and Niger is to take a decision. Selection committee is not the authority, sir. If the selection committee cannot take a decision, that only recommend who are the persons to be selected and who are the persons not to be selected or to be appointed. It is the Niger to take a decision, sir. Selection committee out of its own cannot take any cancellation of the interview. Interview having been set by the Niger itself by the Annexure 1, my lords. You also can see to the advertisement at Annexure 6 at page 31.
Yes.
There is no role of the selection committee to cancel or not to cancel. Then, my lord, this was in the year 2012. The letter my lord and friend read, a recommendation was made in the year 2020-21. From 2012 to 2020-21, my lord, they have been sweeping over the matter, and the selection committee cancelled it. That has not been yet approved by the Niger itself. No document is coming forward that the recommendation given by the selection committee has been approved by the Niger. The appointing authority is not the selection committee, sir. Appointing authority is the Niger who put the advertisement. I was selected and I was called for the interview. The selection committee is just is to take a decision, and they cannot have any independent decision either to cancel the interview or not to cancel the interview. This is unknown to the service jurisprudence, my lord. And more so, my lord, as in the additional affidavit, as my learned friend has said, I have read it once, and again, my learned friend also read it once. 10/8/2021, page 5 may be kindly share and study by 2. राष्ट्रीय विज्ञान संस्था शिक्षा अनुसंधान संस्थान भुवनेश्वर रुपये आपके दिनांक 10/8/2021. While the decision of the authority that the post is to be abolished or post is to be created, it is only as late as 2021. They cannot rise up to the occasion of the today and say, after the writ application was filed and the counter, everything is filed, now they come forward to cover up the wrong committed by them. This is not sustainable in the eye of law, my lord. Now they say that means till 2021, the post was there. It has not been cancelled, only recommendation was given, which was on 11th of January 2022. It was approved that yes, your proposal is accepted. Post of Hindi translator has been changed to a new post, and accordingly, whenever it will be called, he will be asked, and he will be waiting till from 2012, having been selected in the due process of selection. And since he was, no other person could come for the written test, therefore he is really deprived of.
So that is all.
I'll just give a small written note.
My lord, here the petitioner has not been selected as our by my lord telling, or he has not been selected.
He was
It was only-
selection.
it was-
If nobody comes, then minus I am to be selected.
let me complete. He was only shortlisted. He was called for to appear in the written test and subsequent interview along with 4 others.
That means
So it is
my
wrong
time
to
was
say
not
that he has been selected and called for interview. And second thing, my lord,
His prayer is also to consider his
Consider
case
the
for
case?
appointment.
yes,
That is his prayer. He is not going beyond his
yes.
prayer.
Since annexure 1 is no longer survived, annexure 1 has already been
That's all.
cancelled.
That's
when
all.
it was cancelled.
My lord, cancellation is not under challenge. Had it been in case that he has challenged the cancellation, then case would have been different. Cancellation has not been challenged. Your lordship knows section 21 of the General Causes Act says that the authority who issues advertisement has the right to rescind it.
Is it already cancelled, my lord? How can any document to that effect?
That is not under challenge. So that is not under challenge, my lord. The prayers are twofold. First, annexure 6 to be quashed. That has already been given effect to, except the asked in Hindi, my lord. So far as annexure 1 is concerned, prayer to consider the petitioner at par with annexure 1. Annexure has already been cancelled and cancellation has been intimated to the petitioner. He has not challenged. The question is only academic. So far as consideration, the petitioner's case, so far as annexure 1 is concerned, will be an academic one.
All right. Hearing concluded, judgment reserved. Parties may file the note of submissions and memo of citations, if any, within 3 days.
I'll give a written note, my lord.
Within 3 days.
My lord?
Within 3 days.
Yes, ma'am.
If you want, yes, who are you? Government of India. ଆପଣ ଭିତରେ କଣ କହିବାର ଅଛି? କଣ କହିବାର ଅଛି କହୁନାହାନ୍ତି?
My only submission is that even if a candidate has been enlisted for appointment, he doesn't have any right to claim appointment.
He is not claiming appointment. He is claiming a direction to the authorities to consider this case for appointment in the peculiar facts and circumstances. Yes.
About counter ଦେଇଛନ୍ତି
Nine.
All right.
My lord, note that the government opposite part number 3 has not yet filed any counter.
Opposite party number 3 ki?
Sir, ଯାହା ବି ସାର୍ appear କରୁଛନ୍ତି government of India.
Yes.
Niger has already filed.
Item number 8. Kindly one pass.
One pass over କଣ? Already pass over. ଦେଖନ୍ତୁ
Item number 9.
ଏଇଟା କଣ ହେଇଛି ତ? ଏଇଟା କଣ ଦେଖେ? Order. As directed, the concerned staff have submitted explanation for not putting up the letter received from Additional Sessions Judge cum Special Judge in charge Jaipur earlier, though it was received on when was it received? Though it was received on 21/7/2023. Several reasons have been cited, including misplacement of the concerned file. In any case, the concerned staff have begged apology for the lapse and have also undertaken to be more vigilant in future. Stop. The explanation is accepted. The concerned staff are asked to be more careful in future and to more careful in future while dealing with directions of this court on the judicial side. Yes. ଆଉ କିଛି କରିବାର ଅଛି ଏଥିରେ? All right. Yes.
Item number 10.
The Samatri was here, already pass over.
Item number 11.
So item 11, my lords.
Yes.
Lords, on the last date, my lord, lordship had issued notice to OP number 3 and 4, my lords.
No, 3 and 4.
My lords, they have not entered appearance. My lords, notice is also complete, my lords.
Postal traffic for the office to travel regarding services. Office note indicates that notice on opposite party numbers 3 and 4 has been validly served. You are applying for 1 and 2?
Yes.
Mr. Das?
Yes. Yes.
Something about a valid service. If nobody is coming, then we'll
Yes,
consider.
But in fact, it's 2006 matter.
There is, however, no appearance. Stop. Either from the side of opposite party, there is no appearance from the side of opposite party numbers 3 and 4, as also from opposite party number 5, comma, on whom notice was also validly served earlier. Stop. This being a case of the year 2006, this court does not find any justified reason to keep the matter pending. So, as such, particularly when the State Council is present to represent opposite party numbers 1 and 2. Stop. The writ application is therefore taken up for hearing. Yes.
My lord, the brief fact is that, my lords, the petitioner was working as a lecturer in a Joda Women's College, my lords, in the year 1988, my lords. He joined the college, and thereafter, in the year 1995, she was illegally terminated by OP number 3, my lords. That is the governing body of Joda Women's College. And then, that point of time, the college was an unaided college, my lords. And subsequent to my termination, I preferred an appeal before the opposite party number 2, who is the director of higher education. And my appeal was considered, and the order passed by the governing body was set aside on the ground that the no grounds fair opportunity of was not given to me, my lords. And except 2 of my writ petition, my lords. Lords.
So that was set aside.
Yes, that was set aside. Thereafter, what happened was, my lords, this order was not complied by OP number 3 and 4, my lords. I was not permitted to join the college to resume my duties, and my fruits of employment was deprived for. And thereafter, what happened? I preferred in writ petition before this honorable court, my lords, in the year 1996. And parallelly, OP 3 and 4 also preferred an order challenging the order, my lords, before this honorable court. In the year 2006, my lords. In 2005, my lords, though both the writ petitions were disposed, I was permitted to join the college with the direction to the OP number 3 to resume my duties, and their writ petition was dismissed, my lords. And thereafter, I've been continuing as a lecturer in the same college, my lords. And the same order has not been challenged, and the order was complied with, so therefore the order has attained finality. That's what happened was that subsequent to my joining the college, my salary was not disbursed by the college authorities. And thereafter, the regularization period was not done. I was terminated in the year 1995, and in the year 1997, the same college became an aided college by the government of Orissa with a retrospective effect from the year 1994. And I was not disbursed the salary, and consequential benefits of regularization and other benefits were not granted, my lords. And what happened was, my lords, thereafter, I resumed the duties, and subsequent to representations made before the authorities, which is OP1 and OP2, no steps were taken. And OP2, in the year 2006, my lords, before the writ petition was filed, sent a letter to the OP1, which is the secretary of the same department, saying that the person has been illegally terminated. Therefore, there is no fault lying on the part of the petitioner. Therefore, she may be regularized for the period of illegal termination, my lord. That is admitted in the counter affidavit, and they have also filed in. I have also filed an annexer, and they have also filed the same annexer, where they are admitting that the termination is illegal and the regulation should be considered, my lords. So, lordships may come to the counter affidavit filed by them, my lords.
Yes.
Yes, my lords. In page number, my lords, 24, annexer A by 2, my lords.
Yes.
Yes, my lords. In the second page of the same order, running page 25, it says the contents of the High Court's order is noted, my lords, and it is written in view of the above two directions. Principals cum Secretary of Joda Women's College was instructed by letter number to take back Miss Datta in her services. As a result, she had joined the college by principal cum secretary and Srimati had joined lecturer in history on 10/1/2006. Consequent upon joining as a lecturer in history of first post, the principal concerned has requested instruction regarding the regularization of service and payment of salary. At this stage, there is no impediment to allow Srimati Datta to get her current salary with effect from 10/1/2006. As regard to the period of absent of Srimati Datta from her service with effect from 23/9/95 to 9/1/2006, it is stated that she was away from college during that period, being terminated by the management without no fault of her own, and she has not performed her duties as she was not allowed to do so by the GB governing body. As the termination was not based on any procedure as per law, the direction was given to the GB to take back her in service. The period of absence of Srimati Datta is of 10 years, 3 months and 17 days, which is required to be regularized. Hence, the government may kindly consider the case and communicate the decision for taking further follow-up action regarding the regularization of service of Srimati Datta in the history of Joda Women's College for the period of termination, my lords. And my lords, thereafter, this case has been pending upon, my lords. The regularization has not been confirmed. And in the pendency of case, I have been paid a salary, my lords. Interim salary was paid on pre-revised scale as for the 6th pay commission, my lords.
Salary means current salary.
Current salary it was the pre-revised scale, my lords.
Anyway, the correct
Current salary is in paid. And
your claim is for area salary for that period.
area salary, my lords, for consequential
The payment of the salary 3 years prior to the, isn't it? Yes. It is always limited to the 3 years prior actual payment.
2001.
2001. Have you gone through that issue?
My lords, I have not gone through that, my lords, but 2022, my lords, I agree with the fact that, my lords, the court has a discretionary power to grant the lump sum basis.
No question of discretion. It has to be considered on the facts of each case.
Yes, my lords, facts, my lords. As far as the present facts is concerned, my lords, I am relying upon Pradeep Jain in this case.
Page 17.
My lords, so once I'll take through your lords, my lords. My lords, my first case is Manorama Burma versus State of Bihar, my lords.
Yes.
It's 1994 one, my lords. Relevant paras are, my lords, phase 1, para 4, my lords. This is in relation to back wages and termination being illegal, my lords. The court notes that we do not see any justification for the High Court in not allowing the appellant back wages after it came to the conclusion that termination was illegal. Ordinarily, the consequential order of grant of back wages must follow unless there are reasons on record which justify a departure from the normal order. We do not see any reasons on record to come to the conclusion that the appellant was not entitled to back wages. There is also nothing on record to show that during the periods he was out of service, he is gainfully employed elsewhere. In the circumstances, we will allow his appeal and set aside the order of the High Courts by which the appellant was denied the back wages and awarded back wages from the date of termination of service till he was reinstated under the impugn order of the High Court, my lords. This is one of the such judgments. The other is, my lords, I am relying upon Sobha Ram Raturi versus Haryana Vidyut Prasaran Nigam Limited, my lords. Para 3, page 4, my lords. Same case, my lords. Having given our thoughtful consideration to the recent controversy, we are satisfied that the impugn order of retirement dated 31/2/2002 was set aside. The appellant was entitled to all consequential benefits. And this also is a case for consequential benefits also, my lords. This fault lies with the respondents in not having to utilize the service of the appellant for the period of 1/1/2003 to 31/2/2003. But here also I was deprived and they have not permitted to utilize my service. Had the appellant been allowed to continue in service, he would have readily discharged his duties, and my readiness has always been there in the writ petitions, my lords. Having restrained from rendering his service with effect from the period, the respondent cannot be allowed to press the self-serving plea of denying him the wages for period in question on the plea of no work, no pay. This is another such judgment. The last judgment which I am relying upon is State of Jharkhand versus Jitendra Kumar Srivastava, my lords. The relevant paras are, my lords, para 8 to 9 and 14 to 15 minutes. Para 8 minutes. It is an accepted position that gratuity and pension are not bounties and employee
Not necessary.
Not necessary.
This is on the question of pension.
There is another judgment, my lords. Pradeep Kumar also, para 6 to 12 are relevant, my lords. the bench of two learned judges in the said case, having after review the case law in which included a survey of two earlier three judge benches of this court concluded as follows. In Dipali Gundu Suruvai case, the proposals which can be culled out from the following judgments are in case of wrongful termination of service, the reinstatement with continuity of service and back wages is the normal rule. Therefore, the aforesaid rule is subject to a rider that while deciding the issue of back wages, the adjudicating authority or the court may take into the consideration of the length of service. Your length of service is, my lord, 17 years. The adjudicating authority of the court may take into the consideration of the length of service of the employee or workman, the nature of misconduct, if any found to be proved against him, against the employee or workman, the financial condition.
This is important, the financial condition.
Yes, ma'am.
That is why I had a issued a notice. This is after all a private college. So whether it will be in a position to pay you financial benefits for the past 10 years or no is something which this court should consider. Or rather would ordinarily consider.
Yes, ma'am.
Where is your representation to the
Words.
annexure 4?
Yes, my lord, annexure 4.
Only.
4 as well as 15 to 18, my lords.
Pages.
Pages 15 to 18.
Just a moment. I have gone through your writ petition in entirety. Yes, I have also seen your representation. Nowhere you have pleaded that you are not gainfully employed. You should have said that. That is one of the main conditions for the court to grant back wages. You should prove or at least plead that you are not gainfully employed during that period.
Certainly, my lords. That's the
That you have, I've gone through.
That's the law, my lords. I bowed on. I have not pleaded to that effect, my lords. It's a old writ petition also, my lords.
Yeah, that's all. That's all. You were appointed very recently. I don't know, that lady had come.
Yes, ma'am.
Isn't it? So, but I'm not blaming you. I'm blaming the petition.
Yes, my lords.
Isn't it? That is your case.
My lords.
Law is like that.
Parallelly, there is no contrary allegations of my.
It need not be. You have to plead. You have to come forward to say that I have not been gainfully employed. So unless the back wages are not paid to me, that is, why did this theory come out in the first place?
Double employment
This has come out from the labor law, from industrial law.
Yes.
From labor law, yes.
Back wages,
Yes.
because reinstatement with back wages.
Yes, my lords.
Originally, in the line of judgments, if you find from the beginning, from the independence till about 70s, late 70s, you find reinstatement, back wages, no question.
Yes, my lords.
There was absolutely no question. Subsequently, this rider was issued because it was found that the case took a long time for disposal.
Yes.
Maybe 10 years, 15 years. Case was not disposed of in a day. During the interregnum, the person concerned may have been employed also elsewhere.
Right.
And it is quite reasonable that he should be employed.
As is given in case of 17B of the IDA.
Yes. So that,
My lords, here it is not.
that actually prompted that line of,
Yes.
thinking.
It is
Which I
not
should
been.
not say here. So that 17B was inserted into the Industrial Disputes Act.
My lords, he has not been employed, my lords, as per my instruction is concerned. my
No,
lords.
that will not do. That
And
will not do.
lordship's permit, my lords, I can file in.
No, you cannot.
affidavit,
You
but
cannot. No,
very
you cannot
late
do.
stage, my lords.
The court will
Belated
not
stage.
permit you to improve upon a case.
Yes.
Whatever is there.
Very belated stage, I agree.
Whatever is there is there.
Yes, my lords.
But her services must be regularized.
Yes.
Her services must be regularized. At least notionally it must be done. And this court can also consider granting some amount of maybe 50% of the year salary or something like that. Isn't it?
Perhaps yeah, under these premises, your lordships, on 14/8/2023 had directed both the principal and the state to
Yes.
get up-to-date instructions. Unfortunately, I don't have any instructions.
No, because they have appeared, they have notice has been served, still they chose not to appear. What can be done? That is why I have made it clear in my,
Their presence was required.
their presence was required. Then we will close it. Yes, we'll close it. All right. Hearing concluded. Judgment is served.
But recently also Jharkhand High
Parties
Court.
may file their note of submissions and memo of citations, if any, within 3 days. Yes.
But Jharkhand High Court also in a similar situation had awarded the entire back wages. My lord. Similar case, no.
No, there are many cases. Each case has to be seen on its side.
He was
Mr. Mahapatra, I asked you a very pertinent
Agreed.
question you could not answer.
agreed. My lord.
You means your client.
My lord, it is not written in the pleadings. My lord, I will bow down. My lord.
Pleading se nahi, mu representation padiଲି, dita representation
It's not
padiଲି,
mentioned, my lord.
read petition ra pura padiଲି, gote
I-
line code lekha.
I bow down. My lord. It's not. It's a
So you can't improve upon.
Yes, my lord. I agree, my lord.
देखिए कौन होचे? Let us see. Yes.
In item 12 at flag E, I have an ID for liquidation of party,
Flag E.
my lordship.
Whom do you want to implead?
The person who has joined pursuant to my termination, your lordship.
Whether he or she is a necessary party.
Yes, that is the question, your lordship. Appropriate.
What is that judgment? What is that judgment?
In the Punam.
Punam has been subsequently also watered
Your
down.
lordship has also held a judgment in our case. Mr. Author was arguing that even the governing body is appearing, then it's sufficient. They can represent the person who has been engaged prior after that.
Because
But for the former proper party, I have made this application.
hey, you can.
I am satisfying the lordship. I am for the.
No, are you objecting?
I am, no, I am objecting that no, that person is not continuing the college.
Then on that submission we can.
The commission we recorded, that person is not continuing in the college.
Then Mr. Mishra, what remains? Why
Yes.
should he?
Then your lordship,
IA.
recording the concession of
Yes.
alternate senior,
What concession? This is a factual submission.
my lordship.
Shri SS Pratap, no, in IA 5900 of 2004. The petitioner, by means of this petition, wants to implead
That person is not continuing. So another party person.
one Pragya Rani Ponda.
She has been terminated way back in 3. But there is a chakre nahi.
The Pragyan Panda is not continuing. The opposite party number 5 is not continuing.
Yes, because she's a no I fight kochi na. Pragyan Ponda ko party kari api.
So Pragyan Panda is not continuing.
Nobody is continuing.
जहाँ ये कंटिन्यू करते हैं अपोजिट पार्टी नंबर 5 तो करिछो those person which continue
थोड़ा कॉलेज से कंटिन्यू करने बोल दिया था.
Pragya Rani Ponda is not continuing.
Pragyan Panda is not continuing.
The person whom you want to implead is no longer in service.
Yes, ma'am.
So she is not a.
Number 5, whom I implemented the first place in the writ application, even she is not continuing.
No, she is continuing. That is according to him.
Then we should record a submission. If she is continuing, I have nothing to say.
She is continuing.
OP number 5.
OP number 5 August Sunani is continuing.
Yes.
August Sunani is continuing.
I like this by means of this petition. The petitioner wants to implead one Pragya Rani Ponda as opposite party number 6 in the writ application. As opposite party number 6 in the writ application. Sri SS Pratap, Learned Counsel appearing for the governing body.
Yes, my lord.
Submits that said Pragya Rani Ponda is no longer in employment,
Yes.
having been terminated.
No, she is not.
Having been terminated. Stop. As such, this court finds no reason to implead Pragya Rani Ponda as a party to the writ application. The I is therefore dismissed. It is further, Sri Pratap further submits that opposite party number 5, namely
Is continuing against
Augusti Sunani,
it's continuing against the post of bids.
is continuing
Against the post.
against the termination vacancy
Yes, ma'am.
caused by the termination of the petitioner. Stop. So we'll take up the writ application.
Yes,
today?
my lord.
The writ application is taken up for hearing. Yes.
Your lordship, in the present writ application, I am challenging annexure 3 at page number 19. It is the order of Director Higher Education.
Well, first, the basic facts.
Yes, your lordship.
I'm not going to complete it today. I have reserved 2 cases for judgment. I'm not going to reserve it today.
I was appointed as a lecturer in political science. I was appointed in 1997. I was appointed.
1997.
Yes, Your Lordship. Now, for 10 years, I was continuing in my post. Subsequently, to
Lecturer of?
political science, Your Lordship.
Yes.
For 10 years, I have continued, and I was a selection board candidate. That is a very pertinent aspect has to be considered. I continued for 10 years in 2008 without
You were
any
appointed
order.
to state selection board?
Yes, Your Lordship. For 10 years, I have continued. After continuing for 10 years without issuing any order of termination or show cause, they prevented me for discharging duty. And as it was an unaided institution, I approved director for appeal. Now, in 2009, when I preferred my appeal, when it was not taken up, I approached this Honorable Court. This Honorable Court directed the director to consider my appeal expeditiously.
But then it was not an aided institution?
No, Your Lordship.
All right.
I continued for I preferred appeal.
No, first tell me, when did it become an aided institution?
That I have no instruction.
That is as per the 2008 granted order.
Granted it, but with effect from?
That particular date I am not. I will.
So you have to, but that is very important because
Uh.
otherwise the director would have, whether the director has jurisdiction or not, that we have.
No, the director has jurisdiction. When the appeal was heard by the director, at that time director has the jurisdiction.
No, when the order was passed.
Yes, director at that time director.
All right. Then, all right. Because very recently I have come across a case.
Then the act matter was.
Your matter.
Yes, Your Lordship.
You were at the receiving end probably.
Yes, Your Lordship.
A different matter. Sometimes you attack, sometimes you defend.
Yes.
These are tough.
It's a learning process which we learn from.
Yes, yes. We are all learning. Yes, so what happened to the director?
Yes, Your Lordship.
Yeah, the director.
Page 19. Now, pursuant to the direction of the Honorable High Court, the director has disposed of my appeal with the following order, Annexure 3. The Lordship will allow and just place the order of director.
Yes.
Page number 19.
Yes.
I'm starting from the appellant here, the third paragraph. Prior to that, it is the order of the High Court which has been quoted. The appellant had filed appeal petition dated 17/8/2009, which was received in the date on 22/8/2009 and taken up for hearing, giving the opportunities to the parties concerned after the kind order passed by the Honorable High Court as stated above. The case of the appellant in the appeal petition is that he was appointed by the governing body of the college by office order number 20 dated 15/5/1997 as a lecturer in political science. He joined the post on dated 16/5/1997, which was accepted by the secretary governing body. He continued in his post till the end of year 2007-8, and after that, when he entered to the college campus to discharge his normal duty, the secretary governing body prevented him from entering into the college. The next page, Your Lordship. During the course of hearing, the governing body represented through its secretary submitted the original governing body resolution book, attendance register, acquittance roll, and dispatch register to ascertain the validity of appointment of the appellant and his continuance in the college. The advocate appearing for the governing body submitted written note of submission on 24/6/2011 as directed. Heard the matter, perused the relevant records produced by the secretary governing body and written note of submission filed by the advocate appearing for the governing body. The stand of defense of the governing body in the instant appeal petition is that the appointment order dated 15/5/1997 as enclosed by the appellant claiming to have been appointed as lecturer in political science as per resolution dated 2/8/1997 is a false and fabricated document on the ground that the so-called appointment order was issued prior to the passing of the so-called resolution. It has been also stated that there is no resolution of the governing body in appointing the appellant as lecturer, and so also no appointment order has been issued for which the question of allegation regarding obstruction prevention up to the appellant does not arise. Rather, the case of the appellant is a false and concocted story. Considering and examining all the materials on records, I arrived at the conclusion that the appointment order which the appellant has relied upon and annexed as Annexure 1 is a forced one. The so-called appointment order cannot be issued before passing necessary resolution by the governing body. In this instant case, the appointment order is on 15/1997 and the governing body resolution is on 2/8/1997. The GB resolution also does not disclose anything about the appointment of the appellant. In view of the above position, when it's by dismissed, Your Lordship. Now, the crux of the issue is why director has come to this conclusion. He says the initial appointment order which I produced is a false and fabricated one, and I was never appointed before the governing body by the governing body. That was the case even of the governing body before the director. No other aspect has been considered by the director, which is telltale, Your Lordship. Now, it should be kindly refer to counter affidavit filed by the opposite party governing body.
Before the director?
No, before the
Before this court. Okay. Preliminary counter affidavit.
Yes, Your Lordship. Now, if I go by their stand, they have appointed me and they have given the appointment order. That is annexure A/4 series at page number 9.
Yes.
Your Lordship, may kindly read the starting from the top. Anchalika Vastrani Mahavidyalaya Sanchirgaon, dated 15/1987, addressed to me, to Bhavani Shankar Naik, at your so and so. The governing body of AB Mahavidyalaya Sankargaon has provisionally accepted you appointed as lecturer in political science on concerted pay scale of 450 rupees.
But you said you were a selection board candidate?
Yes, Your Lordship.
But the question
No, it's not so.
I was
just a moment.
I was a selection board candidate. Why I'm saying so, Your Lordship, may kindly refer to my RTI application which I have made. It is under page number 31. Sorry, page number 22, Your Lordship. Page number 22.
I don't know how.
Page number 22.
If that is true,
My Lordship.
then
Yes,
the language of the
there are two modes, Your
no,
Lordship.
the language of the the language of your appointment order, which says the governing body has provisionally selected you.
My Lordship.
Now, how if you are selected by the selection board, how can the governing body select you?
I was not sponsored, Your Lordship. I was directly appointed. That is the difference. But this is a fact. At page 22, Your Lordship, may kindly see page 22.
Anyway, that is besides the point. Now so this
Yes,
is the appointment order issued by the governing body.
Governing body. Now, before.
What do they say? What do they say? What is the corresponding pleading in the counter affidavit?
Yes, Your Lordship. That is that.
No, they say it's a manufactured document.
No,
Then I will satisfy. Let submit, I will satisfy.
they accepted that I was appointed, but as per their stand, I was appointed and I was terminated. And before the director, they say that I was never been appointed and the appointment order which I have produced is a fake and forged one. But before this honorable court, after its intervention, they have produced my appointment order. They state that I have been appointed.
Yes.
So there is no dispute about my appointment, Your Lordship, per se. But they've accepted it. If Your Lordship will want, I can praise that paragraph under which they have accepted that I was appointed. Besides my appointment, director has not issued any other framed any other issue. The preliminary point was that my appointment was forged one. On basis of that, my appeal was dismissed. But so far as my contentions which I raised before the director in my appeal petition with regard to my the secondary education form recognition renewal form my name was there in 2007. My name was there. Director has not considered it. He only went on saying that, Lordship, I have also annexed that forged document as per the director at Annexure 1, page number 12.
Yes.
It's my duty to bring to your notice, even if it's against me or with me, it's up to your Lordship. Annexure 1 series, page number 12. I produced my appointment order. The director has only seen the date of issuance, that is February 1987. And he tallied the governing body resolution at 1987. Basing on that, these two, he presumed that my appointment was forged and the governing body, they were appointed me. And this was also stand before the director. They have never accepted that I was appointed. But when I'm thankful my learned senior, he has filed a counter affidavit. He has also enclosed my appointment order and admitted that I was appointed. So where the director has applied his judicial mind.
Yes. That's your case.
Yes, Your Lord. That is my entire case, Your Lordship. Apart from my appointment, the director has not issued any other issue.
All right. Then, yes.
May I submit, my lord? Your Lordship may come to the read petition, Annexure 1, page
Yes.
12. He annexed his appointment. Your Lordship can peruse that. One is Naik, son of Hathiram Naik, village of Samsasana, Kindra, district Kalahandi, is appointed political science lecturer for +2 as per resolution 5.1 dated Buya at 1997. It is a letter dated, it is appointment dated 15/5/97, can have a class. But as per resolution dated Buya at 1997, he has been given appointment. Then this is a manufactured appointment order. Actually, he was given appointment. But this is not his appointment order. He appointed this. Your Lordship may come to my counter. Only simply thing, Lord. Only Lordship may come to my counter.
Annexure A/4.
a waiver is happened, but apart from that, Millard, what happened if this person, when he was continuing as member of Panchayat, elected member of Panchayat Samiti, by suppressing all the facts, he could able to appoint, got appointment from this college. At the same time, he was elected as member of Panchayat Samiti, and he in the year 1997, and he was continued there from 97 to 2002 for 5 years. If at the same time, by suppressing all these facts, he could able to got an appointment from this government. When the fact come to the knowledge of the governing body, he did not attend the college, he remained unauthorized. And some notice was, so-called notice was sent to him. Then when he was not come to the college, then governing will terminate him. This is the fact. By suppressing all these facts, a person elected representative.
Third in part, let's this matter next week.
Next week.
Next,
Just I
Tuesday.
can give a quick reply. Only quick reply. We joined the Annexure 7, they have issued me the NOC. That's what I'm saying, Your Lordship. Just to be kept in mind, Your Lordship.
No.
Have included the document.
Anyway, we'll see that.
ଆପଣ ତ read petition ସେ କଥା
No cross talking, please.
In the previous matter, my name is not appearing in the previous orders, my lords. The previous
your
counsel's name is.
Yes. At the time, in the judgment, it will appear.
next week.
Next week, next Tuesday.
Next week.
I'm grateful.
Yes, Mr. Pratap. Next week, how many? 14th May.
14th oblige.
I'm grateful, Your Lordship.
Item number 13.
Please, Your Lordship. Instead of the last occasion, as per Lordship's direction, I've already filed the requisites, my lord.
No, notice has been issued as it appears,
Yes,
flag
sir.
B.
They have
The postal tracking. The postal tracking report indicates that notice on the opposite party has already been delivered. There is, however, no appearance. Since notice appears to have been received, notice appears to have been served recently, that is on 24/2024. This court deems it proper to grant one more opportunity to the opposite party to appear. Let's this matter next week.
hopeless.
I say 14th May.
Interim order to continue.
Interim order to continue.
Item number 14.
Please, Your Lords. In this case, my lord, the Lordship directed the last occasion, my lord, to the other my lord to file counter affidavit,
Yes,
my lord. The batch of cases. my
Counter
lord,
to apprise the court appropriately. What is this matter?
In fact, my lord.
matter relating to relaxation of age for the post of Shiksha Sahayak. And that was a earlier petition after this honorable court. This honorable court directed to the government, my lord, to consider the grievance of the petitioner. Considering the grievance, my lord, the government rejected the claim, against which they approached this honorable court. A batch of cases since filed, my lord. In any one case, counter is required, my lord, to file since the government.
It is up to him to whether he wants to file any counter or not.
I cannot develop the case.
They rejected only on the ground of say policy decision. So let government file counter, my lord.
I'll file.
No, last time also the same was.
My lord, I know that, but in batch of cases, my lord, we'll file the counter. In fact, my lord, what I am making submission, my lord, Annexure 1 is the rejection order. Annexure 1 is the order after the lordship remitted the matter to the authorities to pass a speaking order. Now, my lord, it is a 3-page order, my lord, where all the facts have been narrated. Most important point, my lord, it is to be added here is that, my lord, the selection was of the year 2016. The rejection was of the year 2018. Another group of persons, my lord, they appeared before the honorable court with respect to the advertisement of 2014. That 2014 case, my lord, it was disposed of, and thereafter, my lord, a writ appeal was filed. And in that writ appeal, taking into consideration the vacancies of that particular advertisement of 2014, there was a direction for consideration of their cases in respect of the persons who had before the honorable court, my lord. So these petitioners, for the first time, my lord, they approached after rejection in the year 2018 for their reconsideration in the year 2022. And thereafter, my lord, there was a direction for consideration of the recommendation.
Anyway, once that part, this court has already directed the director to the secretary to reconsider. and the secretary appears to have reconsidered against them, whatever. So that point may not be very strictly taken up.
To that extent, also, my lord, there are decisions of Honorable Court, my lord. But I am not on that way. Only on this issue, my lord, that whether these persons can also be considered against the left out vacancies or not. Because in the recent case, my lord, your lordship had already dealt with one case, my lord, Mamta Naik case. Judgment was delivered, my lord. But when I placed that particular case referring to this Bobita Satpathy case, your lordship came to an opinion that no, such an opinion cannot be treated as that it is a judgment in personam, rather it should be a judgment in rem.
Because the terms of the advertisement were interpreted.
Yes, madam. That is what, madam. But in that case, madam, that is a case of preference. First preference, second preference, third
That's
preference.
totally different. That is not
Totally different.
in that case, probably I found that the selection process had not completed, had not been completed.
Exactly.
It was left midway.
But at the time of consideration of their cases, my lord, when we rejected their grievance, we are also taken result of that particular decision of the Honorable Court.
But here,
My lord, it is, they relied upon that particular decision, saying that this is the principle and accordingly our case may be also considered. And we have distinguished that particular decision, my lord, in the present case.
Why don't you file a counter then? Learned Sri S.N. Patnaik, Learned AGA, submits that he has solicited necessary instructions from the government and would like to file a counter. Stop. List this matter.
Short date may fix.
Well, 14th May.
Yes.
Counter affidavit, if any, be filed in the meantime.
Hon'Ble.
My lord, 14,
15, 16.
and 16, my lord.
Tinta though?
10.
Correct. 14, 15, 16. So, order.
I don't know, 17.
This matter, Honorable Court may kindly excuse me. There is a special notification superseding earlier endorsements. It was on 26th before my lords. In view of the endorsement given by Honorable Acting Chief Justice, then it was to be listed before Honorable Justice C.R. Das. But I gathered from the today from the DR that special notification or superseding it will be before assignment is my lords.
Yes.
So I hope this is for hearing. Delay has been condoned and questions have been framed. LCR was called for. LCR has not
second appeal.
Second appeal.
We included it in the weekly list. This is a 23. No, this is a 23 matter, Mr. Das.
Again.
There is no
July
July but it a weekly list. What are you saying?
Weekly list supplementary list will be taken up and aguru notice by my prayer before the sun will let the matter this matter be heard and disposed of because the respondents one of the respondent is 86 and another is 77. At any they are far end. At any moment they can die.
May God give them good long life. But you see, I am now stuck up in a situation where 2016 matters are pending. What I'm saying is that I'm not saying that I will not.
But my prayer before this Honorable Court, the let matter be hard and disposed of as quickly as possible.
So you, weekly list है ठीक है तो weekly list है इसको.
After vacation sometime.
Not after vacation. Before vacation हो तो after vacation जीवन दरकार पड़े.
After disposal of second appeal 105.
Is this matter in the week commencing 13th May?
May I pray interim order my kind.
Interim order to continue.
Oblige.
Item number 18th May.
Item number 18. I'm on behalf of my learned senior Mr. Danan Mahapatra. He is on his legs, my lord, but we are filing the compliance affidavit, my lord. And giving the copy to.
What is the compliance affidavit? What is the compliance?
My lord.
Well, let me kindly hear the matter.
There was some calculation.
Yes, Your Lordship. But I was given it to Your Lordships on the last occasion, but Your Lordship had asked me to keep it for today. Your Lordship may kindly sit. My Lord, on the last occasion, my learned senior.
Have you gone through this?
Yes, my Lord, I've just gone through.
What does it say?
My Lord, it absolutely, my Lord, it's sitting in appeal over the orders of this honorable court. My Lord, may kindly say what were the directions that were issued. My Lord, may for a moment kindly have 3561, the contempt 3561. The writ petition order is there at page 6. My Lord, the relevant part would be there starting from page 20, paragraph 9. My Lord would recollect it is
No. If it requires interpretation, this
My Lord,
cannot be.
what interpretation?
Again, if it requires interpretation, then you will have to file another writ application.
My Lord, it is not at all requiring interpretation. My Lord, they are now sitting in appeal over the orders of this honorable
So
court.
that you have to challenge in another writ application.
My Lord, they cannot, my Lord, they're not passing any orders. My Lord, may kindly say what has happened. My Lord, they are saying this. My Lord, no orders have been passed whatsoever. My Lord, now by orders of this honorable court of a writ of the year 2000. My Lord, they have already, which has been held the entire service period, which was because of their inaction. I was suspended from service. That has been held to be bad in the eyes of law. My Lord, may kindly visualize. My Lord, from 2000 till 2014, during which I was getting my subsistence allowance, my Lord, all that period has been held to be bad in the eyes of law. I was getting what? I was getting my subsistence allowance all throughout in that period, my Lord. This honorable court has held that show cause notice is person not maintainable is illegal in the eyes of law because the petitioner has already retired. He is entitled to his retirement benefits and all other stuff. My Lord, may kindly for a moment have that direction what has been issued at page 20.
Page 20.
Page 20 of contempt 3561 of 2023.
3561. Okay.
Again.
Page 20. Yes.
It is in view of this matter, this court finds the show cause notice is even person not maintainable. As a consequence, while declaring the show cause notice by annexure 1 remains bad in law, this court observes that as per the view already taken on the manner the report is prepared, the report involved here is also not sustainable in the eyes of law. This court finds, while entertaining the writ petition by order dated this court had already directed that the disciplinary proceedings initiated against the petitioner may continue, but there shall be no final decision, which order is in operation as of now. In this circumstance, this court, while setting aside the show cause at annexure 1 and the inquiry report enclosed, allows the writ petition. It is at this stage, considering the proceedings were initiated in the year 2000 and the petitioner was aged about 46 years old in the year 2000, having attained the age of superannuation since long, there is no possibility of continuing with such inquiry. There is also no possibility of punishment considering the petitioner has already attained the age of superannuation. In these circumstances, while setting aside the show cause noted by annexure 1 and declaring the inquiry report as bad in the eyes of law, this court directs the Utkal University to consider the case of the petitioner for retirement benefits. Benefit of the petitioner on superannuation, if not cleared, be calculated and paid in favor of the petitioner by undertaking the entire exercise within a period of 1.5 months from the date of the communication of the authenticated copy of this order by the petitioner. The petitioner will also be entitled to interest at the rate of 5% per annum all throughout. My Lord, they then file their show cause reply. My Lord, may kindly have a glance at the show cause reply.
Which they have filed today or they are here?
They have filed it since 2020.
So just to recapitulate, so this court directed them to calculate the retirement benefits.
The retirement benefits and the benefits that would have accrued to me on superannuation. My Lord, seen that?
Same thing.
No, my Lord, retirement benefits is after. And on superannuation, I would be also entitled to the other benefits that were due to me because of the legal orders that were passed, suspending me from service. My Lord, this order has two parts. One is my benefits on superannuation, and second is the retirement benefits. So my lord, this court directed them that if this has not been done, then that has to be done, and within 1.5 months I have to be paid with a 5% interest to be paid to me all throughout. Now, my lord, they file the show cause, my lord. My lord, may kindly see paragraph 5.
Yes.
My lord, they went in appeal in a writ appeal. That order, the writ appeal was dismissed. Thereafter, my lord, may kindly say para 6.
Yes.
That the deponent has due regard to the directions and she is duty bound to comply with the Honorable High Court. Their delay of direction is this, begs apology and everything. Non-compliance is due humility. This deponent begs to drop the proceedings except the contentions above to above. All other contentions in the paragraphs of the contempt petitions are disputed and denied. Thereafter, my lord, I file my rejoinder to this. They say that everything in the contempt application is illegal. My lord, I file my rejoinder saying what has happened. Your lordship, I kindly for a moment have annexure 4 to my rejoinder at page 7 of the rejoinder affidavit. My lord has that order. My lord, this is the order that was there challenged. In pursuant to the order passed by the Vice Chancellor on 11/4/2000, after review the following instructions of Ministry of Health and Family Welfare, Government of India, and guidelines contained in the letter dated this, the office order this regarding sanction of leave, increment, etc. of Sri R.N. Pati, Assistant Director, is hereby rescinded. My lord, this was the rescission order that was there. This was set aside. Thereafter, your lordship may see annexure 5 at page 8. My lord, all the increments that were due to me, this was set aside. Thereafter, at annexure 6 series at page 9, my lord, they sit in appeal over the orders of this honorable court, and what has happened is, your lordship may kindly see the last but one paragraph. The committee, after 3-hour discussion, your lordship has that? After taking into consideration the order of the Honorable High Court passed in this, resolve the following. The rescinded of acceptance of joining report with effect from this to this shall be quashed. The suspension period shall be decided, considered by authority. Thereafter, at page 10, your lordship will see that my suspension period has to be treated as such. Well, now they are sitting in appeal over the orders of this honorable court. Well, they were never even given that laxity. They were directed to comply with the directions that I am to be paid this amount and my service benefits were to be granted. At page 10, my lord, they constitute a committee by the Deputy Registrar Special Cell, the Deputy Registrar General.
Let us now come to your chart.
Your lordship.
You have given an abstract.
My lord, yes, my lord, there are 3 pages. Your lordship may kindly have page 11. That is one calculation of the gratuity, leave encashment, and pension dues. And the first page, that is
no. You say that if I would not have been suspended, I would have retired as additional director in professor scale.
Right, your lordship.
So that how can you claim? How it is not a matter of right.
My lord, it would have been notional. My lord, it has to be notional, my lord. My lord, because I am.
There cannot be any automatic promotion.
My lord, I am talking about the benefits. My lord, I have retired as assistant director only. That was my post. I am saying that I would have, even if I would have continued in that post because of the benefits that were to be given to me because of the increments. I am only claiming that. I have not claimed anything else. I am not claiming that had I been promoted, I would have got the salary. No. I am saying that had I continued in my service with the present post that I was there, I would have retired as such, and thereafter this would have been the amount that would have been due to me. That is what I'm claiming, your lordship.
All right. So you have given
page 1 that a single that is in Roman I, that is one calculation, and thereafter page 11 is the other calculation.
Is the salary?
Yes, page I is the salary due.
What is their reply to this?
But let me kindly see that they have filed right now. Paragraph 2, my lord.
Yes.
That at the outset it is humbly submitted that the petitioner and others were engaged under Population Research Center, a scheme exclusively funded by the Ministry of Health and Family Welfare, Government of India. The petitioner continued as assistant director under the said scheme. The expenditures made under the scheme are funded by the Union of India in the form of granted aid. To facilitate the staff engaged under the scheme, the petitioner and others similarly situated employees are granted the salary and other emoluments.
Yeah, I think you will come to paragraph 4.
Your lordship. The record reveals that the petitioner was extended the scheme as per UGC scale of pay applicable to the position from January 1986 with other emoluments till the petitioner absconded from service on May 1993. The petitioner remained absconded in service from September 1998 to till 30/4/2018. However, the university allowed regularization of the said period as leave due admissible. Accordingly, 606 days of 16,593 were treated as leave due admissible, and while office order number this dated this. The rest of the period till August 1997, that is 1560 days, was treated as EOL. Thereafter, the petitioner was suspended from service pending disciplinary proceedings, and the petitioner continued on suspension on receipt of subsistence allowance till his retirement on 30/4/2014. The Honorable High Court was pleased to quash the departmental proceedings as it would entail no consequence after his retirement from service on attaining his age of superannuation. Accordingly, the aforesaid period of the petitioner has been fixed notionally till his retirement. After notional fixation of monthly salary with annual increment, the university arrived at the last drawn pay would be this. But this
That means the interregnum, that period they have left it out.
Yes, Your Lordship. But that they cannot do. The court has not directed them that. But now, with their calculation itself, they're obliging the Honorable High Court's order, but sitting over it in appeal and adding their own terms and conditions. Thereafter, as per the letter in annexure above, the petitioner is entitled to gratuity for 14 years, 11 months to this, which would amount to this. There being no leave due against his credit, he is not entitled to the encashment of unutilized leave salary. The fact remains that the petitioner continued under the scheme. The Ministry in Health and Family Welfare, which funded granting aid, made any financial support for pension scheme of the employees working under RBC scheme. As per the letter, CPF received salary with matching fund and on addition of some residual amount arose while quantifying the differential and credited in the CPF account. The university quantified it.
I think paragraph 5 holds the key.
Yes, my lord, they are calculating this, which they cannot do now. My lord,
Let us see the order.
Yes, Your Lordship.
Where is that order of this court?
My lord, page 23. Sorry, Your Lordship. The repetition order, page 6. The relevant part is there at page 20. Starts from 20.
Court finds the show person is no person. So the show cause notice was itself and the inquiry report both was set aside.
Yes, Your Lordship.
So when the show cause notice was and the entire disciplinary proceeding was quashed, what does it entail? How could you fix it notionally?
My lord, my learned senior on his legs, my lord. I pray for tomorrow if my lord.
No, not tomorrow. Call him. This is a confirmed matter.
After recess, then my lord.
Call it, pass over. You should have said that earlier. I have consumed so much of time.
I humbly apologize, my lord.
So I thought you will argue the matter. Pass over.
I'm grateful, Your Lordship.
Yes.
I don't know, 9-10.
May I please, Your Lordship?
My lord, I am for the opposite party. My lord.
Your Lordship, may kindly glance to the order dated 10/4/2024.
Mediation proceeding is going on before District Mediation Center, Jawasinghpur. What happened? That
As per
mediation.
my instruction, on 26th, the mediation was conducted. Both parties have appeared, and it has been deferred to 4th or 6th of May.
4th May.
4th May.
So we'll take it up then after 4th May. It is stated at the bar that the mediation proceeding pending before the District Mediation Center, Jawasinghpur, between the parties is now posted to 4th
May.
4th May. Is this matter in 8th May? The outcome date code. Taparu code.
14th.
Or all at 14th May.
I do not 20.
Interim order.
Interim order to continue. Yes.
20.
May I please?
Postal tracking report indicates that shows that Notice on the opposite party has been served on 22/2/2024. There is, however, no appearance. Office note also indicates that nobody has entered appearance for the opposite party till date. The transfer application is therefore taken up for hearing. Yes.
My lord.
You want it to be transferred from which place to which place?
My lord, the CP case.
From Keonjhar to Khordha.
My lord.
On what ground?
My lord, the present prisoner, my lord, the white my lord, who is residing at Khordha, my lord.
Khordha. All right. This is an application for transfer filed by the petitioner wife of CP number 148 of 2023, pending in the Court of Learned Judge, Family Court, Keonjhar, to the Court of Learned Judge, Family Court, Khordha. Stop. Said case has been filed by her husband, opposite party, under Section 13(1) of the Hindu Marriage Act, seeking divorce. Stop. The present application has been filed on the ground that the petitioner wife is a resident of Khordha and is a working lady. Stop. A working lady with a minor daughter. As such, it is difficult on her part to attend to the court at Keonjhar, which is nearly 230 kilometers from Khordha. Stop. Having regard to the counsel for the petitioner submits that it would be highly inconvenient for the petitioner to travel to Keonjhar from Khordha to attend the court on the dates of posting of the case, as she is working as a forest guard and also has a minor daughter, Para. Considering the submissions as above and the pleadings, which have gone unchallenged, this court finds no reason to refuse the prayer for transfer. Para. The transfer application is allowed. It is directed that such and such shall be transferred. Yes. Reply.
21.
Sir, I am appearing the respondent.
Anybody appearing for the petitioner?
I am the petitioner.
Sir, copy of TRPC 46 of 24 minor not served to me. Kindly supply copy of second.
You have appeared through notice? You have appeared through notice?
No, I have not received my lord.
You have not received notice?
My lord, second item.
Second item also you want to appear?
I appear copy.
Let a copy of the transfer application 46 be served upon Sri Naik, Learned Counsel appearing for the opposite party. List this matter.
After vacation, my lord.
Yes, after vacation also. Yes, Mr. Samate. All right.
Yes, my lord. Interim order continued, my lord.
List this matter 25th June. On 25th June, interim order to continue.
22. Both the cases, my lord.
Yes, both the cases. Item 22.
On behalf of Mrs. Das, my lord.
Yes.
There's an application for transfer of CP. Now,
anybody appearing for the other side? Who's appearing for the other side? Let us find out. The name is there.
Yes.
Shall we pass it over? We will pass it over.
I want that it should be go to mediation center.
Yeah, but unless he appears, I cannot send it to mediation. So let the other side be there. So pass over.
Right. 23.
Last occasion notice was issued to the opposite party in his address, which has been mentioned in the divorce petition. But kindly have a glance the noting, my lord.
Postal tracking report. Up to date postal tracking report be tagged to the case record. As the one.
My lord, I am appearing for the opposite party, my lord. I have no objection if your lordship transfers.
Oh, you are already appearing?
I have already appeared. I have filed my Vakalatnama yesterday.
Your good name?
Ananga Kumar Otta.
Sri A.K. Otta has entered appearance for the opposite party. Husband. Stop. He submits that he has no objection. That his client has no objection to the prayer for transfer being allowed. Stop. The present application has been filed by the petitioner wife seeking transfer of CP number 146 of 2023, filed by the opposite party husband in the court of Learned Judge, Family Judge, Family Court, Jajpur, to the court of Learned Judge, Family Court, Puri. Stop. The transfer application has been filed on the ground that you are saying at Puri.
Yes, ma'am.
That the petitioner is presently residing at Puri, and it would be difficult on her part to travel to Jajpur to attend court on the date of posting of the case. Stop. Considering the submissions as above, and in particular, having regard to the fact that the opposite party husband has no objection to the case being transferred from Jajpur to Puri, I am inclined to allow the same.
May I pray, my lord, your lordship may direct for expeditious hearing of the case.
No, the transfer application is therefore allowed. It is directed that so and so be transferred. Yes.
Item 24. May I pick the petitioner pays for the transfer of the CP, my lord, Puri to Bhubaneswar, my lord. The notice is sufficient, my lord. Opposite party not appear, my lord.
Notice is sufficient?
Yes. That's my condition noting.
The postal tracking report indicates that notice on the opposite party has been delivered on 23/4/2024. There is no appearance. However, in order to grant one more opportunity to the opposite party to appear, list this matter on 20th May.
25. Interim order.
Interim order to continue. 25.
This case may also counter not filed, my lord. This is matter related.
Instructions have been received that this petitioner has also been selected.
Yes.
Out of the 247 numbers of provisionally selected candidates are hereby engaged as Shiksha Sahayak.
Yes.
His serial number appears at 223. That will be filing by affidavit.
All right. Learned AGA.
My lord, this is a case of disengagement, my lord. On the allegation of production of
आपको matter दिखेगी बोले
नहीं sir, item 25
case number
WPC 8168 of 2024.
Yes.
Disengagement को challenge कर
But the last instruction is of March 31st March 2018. 2018.
He is challenging the order of disengagement.
Oh, I'm sorry.
With further prayer to further prayer for re-engagement, isn't it?
My lord.
So we'll file the affidavit.
All right. As requested by Learned AGA. Learned AGA request for see, I have asked Learned AGA request for some time to file counter affidavit.
They have been acquitted. So far the present petitioner is concerned, he was never been charge sheeted. But however, on the prayer of the IO, the non-available warrant was issued, that is at page 18. The IO has prayed for issuance of non-available warrant, and I examined the materials whatever in the on the record that the allegation there was a suspicion that the present so far the present role of the petitioner is concerned, he had taken given shelter to some accused persons harboring the coach. But so far the other accused persons, the charge was failed and they have been acquitted. I have the certified copy of the charge sheet. So I will raise all these points at the before. So far the warrant, non-available warrant is concerned.
Kindly say that CRLMC number 1746 of 21.
That was what order was passed, is not uploaded in the website.
No, that I withdrawn.
No, withdrawn was the 1511 of 20. It was withdrawn to 5.
Before my lord justice, Mr. Your lordship.
This
Then
is
my
not
lord,
raised. Dismissed as withdrawn.
Yes.
Then my lord, one BLAPL number 904014 was
90 तो नहीं. ସେଥିରେ କଣ ଥିଲା?
9040 of 2000.
ସେଥିରେ କଣ ଥିଲା?
That order was not uploaded, but he has filed that. That Sandeep Kumar Sahu allies Mowgli Sahu.
Bail application the maintainable ହବନି. NBW ହେଇଛି ପରା. He is outside. How
No,
the
bail he has filed in 2014, and that NBW was issued in 2014, and process under section 82 also issued in 2014.
in any case let him surrender.
Yes, madam. That
Let him surrender.
that is certain.
The 2012 matter or कौन? Considering the nature of accusations and the surrenders made and the submissions made, while not being inclined to allow the prayer made in the petition for quashing of the criminal proceeding, this court, taking note of the fact that NBW has been issued by the court below. The CRMC is disposed of, directing the petitioner to surrender before the court below within 2 weeks. Stop. In such event, he shall be allowed. He was on bail earlier.
No.
In such
He
event,
was not-
want to move for bail. In such event, I will not grant you bail. In CRLMC, I don't grant.
First or second, acquittal of the co-accused be taken into
No,
consideration.
that also. In such
Your
event,
lordship may indicate
in such event, the bail application shall be considered on its own merit, having due regard to the fact that the co-accused persons,
namely Swarup,
standing on the same footing, have in the meantime been
standing on the
acquitted.
worst footing.
Have in the meantime been acquitted by the court in the original trial.
Bad judgment that
है दरकार नहीं अपन से देखिए वो yes
7
letter us
on letter my
the court below has informed that for non-appearance of the accused after his release on bail, NBW has been issued. Stop. The court below is directed to expedite execution of the NBW. Yes.
Item 28.
In that case, extension of that interim ballots. Due to this extreme heat, he also, Lordship, he is in nursing home, Sifa Hospital, your Lordship. Tar kichi te recover very slowly recovering, and condition is not good.
Not good, man.
Now he is in hospital. Taro kidney problem, pancreas problem, and SCP Lordship test करची ये सेथरे
pancreas को रहिलाऊ बड़ी तक
FBS सूची तारो 409 cholesterol 522
ମୁଁ ଡାକ୍ତର ନୁହେଁ ମତେ ଆଜ୍ଞା ସେ ଫିଗର ଗୁଡା କହିଲେ ମୁଁ କଣ ବୁଝିବି ଆଉ କଣ କିଡନୀ କହିଲେ ପାନକ୍ରିଆ କହିଲେ ଆଉ କଣ ତାର ହେଇଛି ଆଉ କଣ କହୁନାହାନ୍ତି ଆଜ୍ଞା କଣ ଆପଣ କହିଲେ ହିଜ କଣ୍ଡିସନ ଇଜ ନଟ୍ ଗୁଡ୍ କଣ ହିଟ୍ ଷ୍ଟ୍ରୋକ୍ ବି କହିଲେ ନାଇଁ କି ଆଉ ଆରେ କହିଲେ ତ ମୁଁ ଲେଖିବି ଅର୍ଡରରେ ନା କେତେ ଥର ଇଣ୍ଟରିମ୍ ବେଲ୍ ପାଇବେ
extend करची तीथर extend ହେଇची Lordship ए extreme due to extreme से आ गोटे last chance
no
Last occasion she also stated that the last thing before surrendering fighting one
Firoz Khan ମୁଁ ମନେ ରଖିଛି
4.5 months
indulgence ଦିଆଯାଇଛି
4 to 6
no chance.
Let them take instruction what is his health condition.
No
they'll से जानी परिवे लॉर्ड
he surrender the jail authority will take care of his jail
मरी जी भाई जो गरम होची
कौन करिवा कौन कर परिवा हमें ଯିବା ଆସିବା ତ ଲାଗି ରହିଛି ଆଉ କଣ କରିବା କିଏ ରହିବ କିଏ ଯିବ କିଏ
Kindly
କରିବ
consider your lordship.
no no
Only for 4 weeks only.
ଦିଥର କନସିଡର କରିଛି
କମିଯିବ
no no no
ଗରମ ଟା କମିଯିବ ଖରାଟା.
twice I have allowed you
Yes, your
extension
lordship, yes.
3 times I will not allow this is the order I have asked for everybody
allowed.
yesterday 3 times I
Three
have
times allowed, not 2 times.
ଗୋଟେ
18,
ଥର
12,
extend ହେଇଛି ତ.
then 31, 1, then 23, 3. Total, my lord, 4.5 months is outside the perspective.
considering these submissions I'm not inclined to allow the prayer for extension of interim date petition is dismissed yes
Item 29.
time is extended till end of April to his 3 months further time is allowed to the court below to extend to conclude the trial.
Item 30.
I may be pardoned, Your Lordship. In that case, fix a date, Your Lordship, for the disposal of main petition. Target करी dispose of वही जीवा.
The NBL application the week commencing 24th June.
ମାଲେସିଆ ଆଗେ ସରେଣ୍ଡର କରନ୍ତୁ 2-5 ରେ ଅଛି ସରେଣ୍ଡର ପରେ
Surrender. I'll file surrender certificate.
24th June.
ଯାଇକି ବି surrender କରିଛି defaulter ହେଇନି ସେଥିରେ.
ନାଇଁ ନାଇଁ ଏକଦମ ଅତି ଅତି ଉତ୍ତମ ଚରିତ୍ରର ଲୋକ ସେ ଏଥିରେ କିଛି ସନ୍ଦେହ ନାହିଁ କିଛି ସନ୍ଦେହ ନାହିଁ 24th June the week commencing 24th June ତା ଭିତରେ ତ ଭ୍ୟାକେସନ ହବ କଣ ହବନି ଆଉ କାହିଁ ଭ୍ୟାକେସନ
Before the in last week of
ହବନି ଯୋଉଟା କାହିଁ କହିଲେ କଣ
surrender certificate ବି file କରିଦେବି ନା.
ହଉ କରିଦେବେ ଲାଷ୍ଟ ୱିକ୍ ଦେଖିବେ 20th May week commencing 20th May ନାଇଁ ଖାଲି this is matter in the 20th May ସେଇଟା ମ୍ୟାଟରଟା ସେ ତାଙ୍କ ମ୍ୟାଡମ ଙ୍କ ଯୋଉ ମ୍ୟାଟର ହେଲା surrender certificate be filed in the meantime ଏଥିରେ କଣ ଅଛି this matter item 30 ଚାଲ ଗୋଟେ ପାସୱାର୍ଡ ଆପଣ ବିଷୟରେ କାଇଁ ଫାଇଲ କରୁଛନ୍ତି ମଡିଫିକେସନ ଫାଇଲ କରୁଛନ୍ତି ତ ନାହାନ୍ତି yes 31
item 31
ନାଇଁ ସରିଯାଉ 32
Modification of say condition number 1, my lord, because the petitioner is a IAS due to election duty, he could not, my lord, reach the court and my lord has fixed the term and condition to each date of posting and no representation shall be there.
all right it is submitted that the petitioner is a police officer and is presently and has been presently assigned election duty with election duty. As such, it would not be possible on his part to appear before the court below personally on each date of posting of the case. Having regard to the submissions as above, condition number 1 is waived for a period of till the end of election.
The end of trial. The representation may be
Till the end of election. During such period, the petitioner may be allowed to be represented through his counsel.
I am for the information.
Yes.
item 33
कौन सी करोड़ ही थिला ऑर्डर थे the figure 350 occurring in paragraph 4 of order dated 20/12/2023 be corrected as 850. Yes.
item 34
Sir.
item 35 item 36
35
extension of time
35 तो
again
the first time it has come
first time milord
all right 2 weeks time
another milord your lordship has imposed 1 lakh instead of 1,70,000.
We to submitted that the petitioner is because of financial stringency, the petitioner is unable to furnish cash security of rupees 1 lakh, for which he is unable to take benefit of the order passed in his favor. Considering the submissions as above, the order dated so and so is modified only to the extent of directing the petitioner to deposit rupees 70,000
Yes,
as cash security instead of rupees 1 lakh, with all other conditions remaining intact. Hello, stop. Further 2 weeks time is allowed.
obliged.
Item 36.
May I please, Judge? You know, I'm in custody since 28/3/2020.
Is it a regular criminal appeal or in the nature of
No,
bail?
Lordship, the special.
Special.
bail.
Notice has been issued.
Yes, notice in made sufficient.
Notice has been made sufficient.
You see, the state only taken time thrice, Your Lordship, for production of the CD.
It's not required because
It-
on the
J-
JJ
Lordship notice.
Oh, this is JJ.
JJ.
So what happened?
My learned friend taken time to verify whether the person released on bail.
Yes,
The
yes.
Similar.
Yesterday it was
petition-
there.
Not similar. This person is the
No, I'm coming. my lord.
person who was almost there from kidnapping to murder. He was.
Yes.
देखिए कौन
May I please, yours? You know, date of alleged occurrence 7/2/2022 and FIR 14/2/2022 and arrest is 23/2022. And so far my application part is concerned, that is on the basis of co-equal statement also Bhagyadhara. And the 161 CRPC Sarojini Sethi, who is happens to be the eyewitness to the case, Lordship, stated that I am one of the unlawful assembly lords. The person those who released on bail, they are one Parameswar Raut, adult lordship. And another Niranjan Sethi.
Similar matter, I think I have dealt with.
Yes, your lordship granted
Also
bail.
rejected.
No, granted bail. Your lordship granted. Yes,
One your lordship allowed.
granted bail.
He is coming under similar footing matter like Sarmista, Jhuna, Ranjan and Bhagyadhar. Their bail was not allowed.
And I am juvenile, your lordship. So for my application part has to be taken into consideration. So how far I have been taken part, so far the assault part is concerned. Only one statement also I am placing, that is the statement of your lordship, Sarojini Sethi, your lordship.
Please, place it. What is your name?
My name is, your lordship, Nilu alias Vivek Naik.
Yes.
मोर नाम सरोजिनी सेठी ओरफ सुनी मु आज 14/3/2022 पुलिस आकर देवा मोर बयान नहीं कि जे मु शर्मिष्ठा मैडम को दयाल बुद्ध आश्रम हाईटेक छक भुवनेश्वर आज प्राय 1 वर्ष में केयरटेकर भाव कार्य करी आसुछि। मु मोर छोट 3 वर्षर पुओ सह आश्रम रहू। शर्मिष्ठा मैडम स्काई टावर डुप्लेक्स रे रुहंती, सेटारे ताकरे संपूर्ण न्यूज पेपर ऑफिस अछि। आम दयाल बुद्ध आश्रम को 2 महलार तळ महलार बुढ़ा बुढ़ी रुहंती। अपर महला रूम रे मैडम विभिन्न समय रे वेब चैनल पई स्टोरी शूटिंग करती। आम गाँ पाखे गोड़े रोता निरंजन सेठी रिलीजन बेल जहाँ को मैडम सार बोल डाकती, से प्रति सप्ताह 2-3 दिन मैडम को भेटिया आश्रम और तांको ऑफिस को आसते। 2-3 घंटा रहिबा परे फेरी जाती। कैमरामैन मानस स्वाई मैडम को कौन गोटे रेकर्डिंग चिप को नहीं झगड़ा हेबारु गत फेब्रुआरी मास प्रथम सप्ताह मानस स्वाई और मैडम को ऑफिस को आसुन कथा मैडम ताकू फोन कले मते से फोन उठा ना बोली मैडम को ठारू सुनिछि। तेणु मैडम विभिन्न लोक को फोन करी मानस स्वाई विषय पचारि तार गतिविधि उपर नजर रखिथिबा कथा निरंजन सेठी सार कथा होइतबार मु बहु बार सुनिछि। गत मास 6 तारिख संध्यारे मैडम काठू खबर पाइले कि मानस स्वाई गोटे विवाहर और वीडियो शूटिंग पई चांदबाली जाउछंती। मैडम निरंजन सेठी के सह कथा होई से झोना मैडम भाग्यधर विवेक और राज को साथी धरी तांको सांत्रकार चांदबाली जाइथिले। ता परदिन प्राय 11:30 समय मैडम झोना मैडम भाग्यधर विवेक और राज सहित मानस स्वाई की धरी से सांत्रकर आश्रम पहुंचले और मानस को उपरमला को नहीं गले। से रूम रे कपाट झरका बंद कर चिप बाबद पचर करते। किसी समय पर मैडम राज विवेक और भाग्यधर को कार रे कुआडे नहीं चली जाइथिले। संध्यारे पुणी राज मैडम विवेक भाग्यधर आश्रम को आसिथिले। सेही समय निरंजन सेठी मध्य आश्रम को आसिथिले।
से मध्य मैडम और अन्य मानक सह मिसी मानस को मानस को मारपीट करी चीफ विषय पचरा उचरा कर देखी निरंजन सेठी निरंजन बेल लड़सी किछि समय पर मैडम राज भाग्यधर और विवेक मानस स्वाई कार नहीं जाइथिले और 1 घंटा पर पुणी आश्रम उपलम्बर गोटे रूम रे रखी बाहर पुणी चाबी दे मैडम चाबी नहीं समस्त पलि जाइथिले तार परदिन सकाळ प्राय 9 घटिका समय मैडम और झुना मैडम दुहे आश्रम को आसते मुझे बजार को सौदा किणा जाइथिली किछि समय पर मु आश्रम फेरी आश्रम सेवा बुढ़ा बुढ़ी रोषे करी को खाइबा को देली दिन 2 घटिका समय मैडम परे मैडम मते 100 टंका दे गोटे कपड़ा आने कहले एणु मो आश्रम बाहरी सुंदरपदा बजार को जाउथिबा समय आम आश्रम आगरे मैडम को कार राज विवेक भाग्यधर बसी सिगरेट टाणुथिबारे मु देखिली मु सुंदरपदा मार्केट विभिन्न दुकान खोजी कपड़ा न पाइबारु मैडम को फोन करथिले मात्र तांको मोबाइल रो स्विच ऑफ थिला तेणु मु झुना मैडम को मोबाइल को फोन करियो तांको मोबाइल मधे स्विच ऑफ थिला तेणु तांको भाउजन को मोबाइल फोन को फोन कली से कहवा मुताबिक मो आश्रम को फेरी आसिली मो आश्रम को फेरी देखिली मैडम कार आस नथिला कि मैडम को आश्रम नथिले वो आश्रम गेट खोला थिला किंतु बुढ़ा बुढ़ी रहउतवा घर गुडी कारपट बंद थिला से दिन मैडम आश्रम को आसी नथिले ता परदिन सध्या मैडम आश्रम को आसिले मु ताको मानस विषय पचार से मते मानस्टर चीफ पाइबा पर ताको नै बरमुंडार छाडी दैतिया कथा कहले सो एंटायर किंगपिंग ऑफ द क्राइम इज लॉर्डशिप शर्मिष्ठा इज कंसर्न and so far this statement is concerned my role is only unlawfully accessible there is no specific attack against me lordship and another statement I
no in the previous order I have written Sarmishta along with her associates namely Jhunna Bhui Nilu alias Vivek Naik you are Nilu
I am Vivek
then Bhagyi alias Bhagyadhar Naik and Raj alias Ranjan Naik came to Hon'Ble in a car owned by Sarmishta with preparation to kidnap the deceased on Sadhui while the deceased was moving in a two-wheeler along with their assistants. Accused Sarmishta and her associates intercepted them and took the deceased to Royal Ashram located at Kuha village. They demanded the memory chip and severely assaulted him by means of bamboo planks and wooden sticks. So you are part of the assembly which assaulted.
no assault part is not against me lordship
How do you say so? On what basis are you saying so?
Sarojini Sethi statement lordship is the immediate eyewitness lordship so assault part ताकू से घर भीतर रखिले बाड़ेइले से कथा ये विवेक बाड़ेइछ बोली कोने जगह रिलेजन सेठी से स्पेसिफिकली सेही समय रिलेजन सेठी सार मध्ये आश्रम को आस्थिले से मध्ये मैडम अन्य माने से मानस को मारपीट चिक करथिले सो निरंजन सेठी हैज रिलीजन बेल लॉर्डशिप so now my respectful submission I am a juvenile lordship there is no specific overtake against me and so far prime consideration my case is concerned I am only 10 pass class student lordship I have no criminal background and first time I have been made involvement in this case and in the meanwhile another thing made development lordship 2 of the PWs have been examined and their deposition have also been filed they have also not been implicated the present petitioner their name is lordship
That Sarojini Sita my lord was in the meantime examined. Let he file that deposition copy of the Sarojini Sita.
Yes, Mr. Jana.
My lord.
He is a major, she is a major witness.
Yes, my lord.
Why don't you file that deposition? Sarojini Sita.
By the time I file this application.
No, I call it, I thought call it, if you can obtain it.
Lordship, may kindly call for so far the Sarojini Sita statement, lordship.
So which court it is?
It is a lordship, the court of Bhadrak, lordship.
We'll call
additional session judge Bhadrak, lordship.
In course of hearing, it is stated at the bar that in the meantime, trial has commenced with some witnesses being examined. Stop. Out of such witnesses, the eyewitness Sarmishta Sita, Sarojini Sita is said to have been examined. The court below is directed to transmit copy of the deposition of said Sarmishta.
Sarojini Sita.
Sarojini Sita by email to this court. Place this matter next week. This order will be communicated to the court below forthwith. Next week, weekly list as well.
Specific.
Next week, next Tuesday. Next Tuesday, next Tuesday. Yes.
Item number 8. Your report has also been called, my lordship. Last August report has been called for.
Which report?
So far the probation of offender report has to file regarding the conduct of the petitioner. And
so tomorrow we'll consider.
Father has also been filed an affidavit taking care of the minor lordship.
Item 8 on behalf of Mr. S.N. Patnaik, may I pray for tomorrow. Because he was called in another court, he was ready in the case.
Yeah, what do you say? Tomorrow. Well, this matter tomorrow is paid for by London State Council. This is a part-heard matter.
Yes.
ମୁଁ ରିଜେଣ୍ଡରଟା ଦେଇକି ଅଛି
ଆଜି ଦେଇଛନ୍ତି?
ନା ନା ମୁଁ ଦେଇ ଫାଇଲ କରିଥିଲି ନୋଟିଂଟା ଆସିଛି ନଟ୍ ଫାଇଲ ବଟ୍ ରେକର୍ଡ ବୋଧେ ଅଛି
ରିଜେଣ୍ଡର ଅଛି ଦେଖିଥିଲେ ଦେଖିଦିଅ
in the rejoinder I filed these orders only.
But I think he was here right now.
You copied it.
No, he was called in another court.
All right.
Copy.
We'll find out. We'll find out. Yes. Next.
So item number 10.
10. Yes.
That second of the previous day, yesterday.
And yesterday I was not convinced.
No, I do understand. On some other point of law, my lord, in addition to this, I will satisfy this. My lord, so far as facts is concerned, my lord, I did not want to lose your valuable time, my lord, your lordships, because I have already stated the facts. So far as point of law is concerned.
Is a question of cancellation.
Yes, question of cancellation. My lord may kindly come to the ingredients of execution of gift and its revocation. That is section 126.
Transfer of property act.
The donor and donee may agree that on the happening of any specified event which does not depend on the will of the donor, a gift shall be suspended or revoked. But a gift which the parties agree shall be revocable wholly or in part at the mere will of the donor is void wholly or
here the gift was executed by your mother.
Mother and me also.
You were one of the signatories.
Signatory, but owner is my.
Your age was 23 years. 23. Now you are claiming ignorance. I did not know what was that. It purported to be a power of attorney, but it was actually a gift deed.
Exactly.
This is your case. So what was the point that I raised? I wanted you to answer.
On that, once my lord, this deed has been executed, there is no bar as such under section 68 of the Evidence Act to direct the defendant to produce evidence, the witnesses to the doc. It is the burden duty of the plaintiff to prove the document that it has not been executed in fact. This is the question, your lordship.
Yes, that is
the burden is on my arm, my lord. This is the question, your lordship has put. My lord, your lordship may kindly give me some time, my lord.
You cannot place the burden on the defendant. To prove 68.
My lord,
when you are claiming yourself.
My lord.
And secondly, there is no concept of revocation of the deed simply by way of a cancellation.
My lord,
you have to go to the court.
My lord, that part of cancellation is, my lord, incorrect. Should not have been before the registrar itself. Unilateral cancellation is.
You may do it, but it has got no. You may do it for collateral purposes. It can be used for collateral purposes, but it cannot be admitted into evidence in court.
Not rightly, it has not been admitted as evidence.
So what remains then?
My lord, to that part, my lord, that extent, my lord, I am not in this position of law. My lord, हजू टिके दिन मत समय देबे गुडे पॉइंट ऑफ लॉ हम टिके हजू कहबे आई मे नॉट
काली समय देले आजि पई
नहीं मु आर्गुमेंट करिबी ऑन पॉइंट ऑफ लॉ
आर्गुमेंट करे तो मना करिबी नहीं आई विल नॉट स्टॉप यू फ्रॉम आर्गुइंग बट दिस इज द पॉइंट
my lord,
confirming judgment.
Some other points are there, my lord.
What other
burden, my lord, burden
see what the
onus is right now on the part of the defendant. I will satisfy your lordship.
No, onus, you see, when will the burden of proof shift?
Shifts.
You claim that this is not a document which it purports to be. It purports to be a gift deed, but it actually you thought that it was a power of attorney. That is why you lent your signature. And your mother is not a pardonation lady. Not a pardonation lady. But she has signed in English. You have signed in English, and you were a major when you signed it in English.
But in my plaint, I have written that even though I have signed in the language of English, but only to that extent I can read. I cannot understand the language of English. My lord, it is not possible, my lord. Perhaps in my lord, perhaps suppose a person passed matriculation, even class 5 also. Class 5, my lord. My lord, assuming for the sake of argument, class 5 he passed. He can sign in English, my lord, but he may not understand what is the contents written in the document. My lord, that is the presumption, my lord. Even a class 3 student also can sign in English. But it cannot be said that he can understand everything what is written in the document.
But that presumption may be done by your lordship, taking into consideration 114 of.
No substantial question of law, Mr. Samant.
No, I will satisfy.
Confirming judgment, I will grant to. If you want to further.
After launch, baby, what you call it?
After lunch, after lunch. After lunch, if he wants to argue, let him argue. So what is wrong in it? You will get opportunity to argue, don't worry. But the point I am just asking you to focus on the point.
Only on the question of law, my lord.
You came to the court.
No, yes.
It is not the defendant. You came to the court,
my lord,
seeking cancellation of that deed or declaring it as null and void. What was the suit for?
It's a suit for declaration saying that the deed which has been executed in favor of so-and-so person, it has been
is null and void.
Void. And I mean, the second prayer is also there. The revocation deed will be given effect to. That even though it is admitted, will not be admitted, but can be used for collateral purposes, considering the circumstantial case.
But how can the revocation deed be given effect to?
No, it will not be given effect.
You see, if you want to, there is a specific performance, specific relief act. There is a provision for cancellation. You have to approach the concerned court.
But
the defendant has filed a counterclaim in this case. Isn't it? What is the counterclaim?
Counterclaim is saying that the deed which has been revocation deed, that will be given effect. The revocation deed which has been made unilaterally at the instance of mother of the plaintiff, that is not binding upon me.
He need not make that.
Not necessary.
He need not make that.
Necessary. But he has made. And that matter, that
abundant
advantage to me.
Abundant caution he has done it, but he need not come to the court. So the counterclaim has also been rejected.
No, it was allowed.
Counterclaim was decreed.
Decreed.
It is because of as a natural corollary to your suit being dismissed.
Even not necessary, my lord. Even if it is not accepted, in fact, his prayer, still then also he.
All right, I'll grant you 15 minutes time after lunch. ଆଉ କଣ ଅଛି ଆଉ ପାସ ଓଭର ଗୋଟେ ଦିନ ରଖିତେ ପାସ ଓଭର କଣ ଅଛି
Password, I don't know the 18.
18 ଟା none appears. Let's this matter next week. नहीं contemplated hearing होता लगा hearing होता लगा हम senior ऐसे will go after lunch yes.
So I don't know 22.
22 yes.
22 ଆସିନାହାନ୍ତି Mr. ପଟ୍ଟନାୟକ is there. ଆଉ ଗୋଟେ ଦିନ ରହୁ
କେବେ କର 8th May. All right, let's just matter on 8th May.
Entry order
to continue.
So I don't know 30.
SS Rai. None appears. Let's just matter next week. What?
So I don't know 31 tables.
Oh, 31. Sorry. Next week.
So I don't know 34.
34 also next week.
Sir.
Yes.
Supplementary list item number 10.
Supplementary खोला है जी.
Then question of the definition of contract. Sets of promises and promises forms consideration is an agreement, and when an agreement is enforceable by law, this is contract. My lord may kindly see the definition of contract.
Yeah, not necessary.
I am saying because the deed itself is a contract. Deed itself is an agreement, and the considerations, forms set forth in the agreement itself is a contract. And if it is a contract, then my lord, if it has been obtained by undue influence, then burden always lies upon the person in whose favor the deed has been executed.
No.
But to that respect,
here, Mr. Samantha, there's a slight confusion. It says gift may also be revoked in any of the cases in which, if it were a contract, it might be resigned. So it must have elements of contract.
Yes, madam.
So you come to the gift in question, whether it has any element of contract.
Exactly, madam.
But it must be contingent upon happening of something, or because of this gift, I would want this much in return. Or
Madam,
something
it has
like
been exhibited as Exhibit L that gift deed is in me. There is element of contract. That is why I'm.
What is it? What does it say?
Yes. Here it is written in the gift deed. It's actually in the recital shows it's a power of attorney, but gift deed has been executed. It is mentioned in the gift deed. May I read, my lord, some portions? That in consideration of natural love and affection, of the word consideration has been used, that in consideration of natural love and affection of the donor for the donee, the donors do hereby and hereunder grant, convey and transfer, give any other things jaha kariba katha se kale. It is lekha hala subject to the only condition. Man, there is a condition precedent clause. Condition that donor number 1 should be allowed to enjoy the said 2 gifted builders during her lifetime, and thereafter he will enjoy. Well, there is a condition precedent in the gift deed itself. Well, it shows there is a contract between the parties. And contract, why I'm saying, because the definition of contract says promises and sets of promises put forth for consideration is an agreement. Here sets of promises are there from both the sides. Either you do it or you will not enjoy this. If you will do it, then it is a vested contract. You will get this enjoyment subsequently. So this agreement, this is a deed in the shape of an agreement to do certain act or to refrain from doing certain act. That is called promise. And when promise and promises are set forth for consideration, that is called agreement. And when agreement is enforceable, that is a contract. If a contract is suffered from undue advantage, coercion, threat, misrepresentation of facts, then it will be said voidable under section 19 of the contract.
Even assuming what you have said, supposing let us accept that it involves elements of contract, and according to you, it was a product of undue influence or fraud or what a misrepresentation. Then it was the onus was on you to prove it.
Yes.
The courts both the courts below found that you could not discharge that burden.
Exactly. Burden doesn't lie upon me when contract suffers from undue influence and misrepresentation. My kindly see contract. Undue influence burden lies upon the person in whose favor the deed has been executed.
On certain conditions being fulfilled. On certain conditions being fulfilled by the plaintiff, generally the burden will.
Subject to correction, my lord. This is, my lord, may kindly see.
No, yeah, you are free to make your submissions. Don't worry, you can make your submissions.
My lord, I may be incorrect, but
no, everybody may be incorrect. But you have to establish certain foundational facts before the burden can shift to the other side.
My lord, then why?
Simply, otherwise, what will happen is every contract. Any person wanting to resile from that contract will say that it is undue influence. So the other side will be called upon to prove. No.
Yes. Undue influence, it is section 16 of the Contract Act.
Undue influence to it misrepresentation.
Movie more pleadings
misrepresentation.
Undue influence.
Okay, both. Because you said that it was designed to be a power of attorney.
And undue influence.
You said it is designed to be a power of attorney.
My lord, undue influence defined. A contract is said to be induced by undue influence where the relationships subsisting between the parties are such that one of the parties is in a position to dominate the will of other and uses that position to obtain an unfair advantage over the same. Here in my present case, he is my own brother. My lord, when I was a helpless lady, since my husband died, I took assistance of my brother to help me because I was not in a condition to maintain my family. Taking that advantage, he took unfair advantage over me because he was under a dominating control over me by that time because I was helpless.
You paraphrase your sentence. He was in a position to dominate your will. That is what you want to say.
Then, where a person who is in a position to dominate the will of another enters into a contract with him and the transactions appears on the face of it or on the evidence adduced to be unconscionable, the burden of proving that such contract was not induced by undue influence shall lie upon the person in a position dominate the will of other. Well, the person who is dominating the will of other and taking advantage of such dominancy, he created such a document. Then the burden, when the allegation of fraud is or undue influence or misrepresentation of fact comes forward, then it is always lies upon the person in whose favor the deed has been executed. Well, once the burden lies upon the person, means in favor of defendant, against defendant, then 68 of Evidence Act will come into play. And if 68 of Evidence Act will come into play, my lord, I have a case. Because it is the burden duty of the defendant to prove the certain document, this document, by leading at least one witness to the dock. It has not been complied with. Well, that is why that's what I was about to say. Well, 68 of Evidence Act ଆସିବା ପାଇଁ ଏଇ provision ଗୁଡାକ ହଜିଙ୍କ ପାଖରେ।
All right. That's Sri S.K. Samantrai, learned counsel appearing for the appellant. Also peruse the impugned judgments. Considering the submissions, the second appeal is admitted on the following substantial question of law. D ଯୋଉଟା ଲେଖା ହେଇଛି page 9 ରେ ସେଇଟାକୁ quote କରିବୁ. Whether non-examination of the attesting witnesses to the gift deed in question by exhibit L at the instance of the defendant nullifies the decrees under when the whether the courts below committed error in not considering the effect of non-examination of the attesting witnesses to the gift deed at the instance of the defendant as per section 68 of the Evidence Act, particularly when execution of the registered deed of gift is specifically disputed by the executant on the ground of undue influence and fraud and misrepresentation. All right. Issue notice. Respondent by registered post with AD. Within 3 working days. For the LCR. List this matter. In the week commencing 8th July. Yes. I will publish.
Item number 18.
Well done, Mr. Samatra.
I am obliged.
Yes. Item 18.
My lord, may I kindly have the affidavit that I have again sworn in today for a moment, my lord.
Affidavit. Mr. Mahapatra, before I open the affidavit, I expect that if the order is there clear, well, it should be complied with.
My lords, with the due humility, my lords, I discussed with officers, also required to know about the position of law. Thereafter, my lords, I conveyed them, this up to that extent, they are entitled to as per the direction and you will be entitled to get it.
So let us first go to the order of the
matters. That exactly matters.
Annexure 2.
Before going to my affidavit, it will not now help to me, my lords. Now at present, the thing is that let us understand what is the judgment.
Well, let us see. Let us come to page
20 or
10,
page 20 in the
okay,
second
other content.
Your lordship. Page 20, 35, 61.
Minutes. Page 20.
Page 20.
20.
No,
Paragraph 9.
Page 21 को असले.
My lord, let us have a glance from the beginning, my lord.
The show cause notice is even per se not maintainable as a consequence while declaring the show cause notice by annexure 1.
You already taken in the matter, the report is prepared. The report involved here is also not sustainable in the eye of law. This court finds while entertaining the writ petition on by order dated 18/2020, this court has already directed that the disciplinary proceeding initiated against the petitioner may continue, but there shall be no final decision, which order is in operation as of now. In the circumstance, this court, while setting aside the show cause at annexure 1, The inquiry report enclosed allowed the repetition.
Sati.
Allowed
So
the-
there are two things. Show cause notice.
Quashed.
Under annexure 1, quashed.
Quashed.
Inquiry report, quashed.
ତାପରଟା ହଉଛି ଅପରେଟିଂ
Yes,
ପର୍ସନ କମ୍ପ୍ଲାଏନ୍ସ ଯୋଉଟା କମ୍ପ୍ଲାଏ କରିବାକୁ ପଡେ
No, what will be the effect? Is that clear or not?
କମ୍ପ୍ଲାଏ କରିବାକୁ ପଡେ ତାପରେ ଲେଖିଦେଇଛି ପୁରା କ୍ଲିୟର ଅଛି it is at this stage considering that the proceeding was initiated in the 2000 and the petition was aged about 46 years old in the year 2000 having attained the age of superannuation long since and there is also no possibility in continuing with such inquiry there is also no possibility of punishment considering that the petition is already attained age of superannuation. In the circumstance, while setting aside the so-called notified annexure 1 and declaring the inquiry report as bad in the eye of law, this court directs the university to consider the case of the petitioner for retirement benefit only, but not only retirement benefit. So now benefits, the retirement benefit, you will be entitled to with interest at the rate of 5%.
The Majida got achi. Benefit of
the petitioner on superannuation, if not clear, be calculated. Retirement benefits. Obviously, on superannuation, you will be entitled to some retirement benefits, and that you will be entitled to.
Benefit of the petitioner on superannuation means gratuity, leave salary.
Exactly. Gratuity, leave salary, also pension. Tinita. Just a minute, fine. The outer commutation provision. Commutation here in this case, what happens?
Commutation depends on who?
Depends upon him. That is his option. But Tinita. ତିନିଟାରୁ ଗୋଟେ ହଉଛି ଏମାନଙ୍କର ପ୍ରଥମେ ଆମେ ଦେଖିବା ଯେ ୱେଦର ଆଉ ଗୋଟେ ଅଛି ଜିପିଏଫ ଟା ଅଛି ଜିପିଏଫ
ୟାଙ୍କର କଣ୍ଟ୍ରିବ୍ୟୁଟର ଥିଲା
ୟାଙ୍କର କଣ୍ଟ୍ରିବ୍ୟୁଟର କି ୟାଙ୍କର ପୋଜିସନ ଟା ହେଇଛି ମୁଁ ଧରିକି ତାଙ୍କ ଲିଷ୍ଟ କରିକି ଦେଇଛନ୍ତି କାଲକୁଲେସନ କରିକି
so ଦେଖିଦେବା ଏଟା so these three things have to be
calculated so question ଅଛି ସେଇ ତିନିଟା ଯାକ ଜିନିଷ ପାଇଁ ଆରଥର ମୁଁ ଟାଇମ ଦେଇଥିଲି I sat with these people ସେଥିରେ ମୁଁ ଦେଖିଲି ଯେ ପ୍ରଥମ ହେଲା ଯେ ଟିକେ ଖାଲି ତିନି ଚାରିଟା ଫ୍ୟାକ୍ଟ ଦରକାର ହଉଛି ତ ବୁଝିବା
but what about the period during which he was under suspension by operation of the show cause notice that is gone
ମୁଁ ଟୋଟାଲ ଡାଟାର ଲିଷ୍ଟ କରିକି ଆଣିଛି ଆପଣଙ୍କୁ ଦେଇଦେବି ସେତେବେଳେ ମୋ ପାଖରେ କଥା ଖାଲି ଗୋଟେ ତିନିଟା ଜିନିଷ ଟିକେ ଦରକାର ଇଟ୍ ନେସେସରି ଫର ଆପ୍ରିସିଏସନ ଅଫ ଦି ଫ୍ୟାକ୍ଟ ଇନଫ୍ୟାକ୍ଟ ଏଇଟା ହଉଛି ପପୁଲେସନ ରିସର୍ଚ୍ଚ ୱିଙ୍ଗ ଏଇଟା ଗୋଟେ ସ୍କିମ୍ ଅଣ୍ଡର ଏ ସ୍କିମ୍ ଅଫ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଅଫ ଇଣ୍ଡିଆ these appointments not by the university but under the scheme. He was appointed statistical, then he was appointed assistant director. I think assistant director of the population scheme. The payment of so far population scheme is concerned, these employees, those who are working there into the scheme, that is being funded by Ministry of Health and Family Welfare. Ministry of Health Family Welfare grant master catching the Tadurame. Question dispute asela. ଯେ ଏମାନଙ୍କ ଦରମା 19 years ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଅଫ ଇଣ୍ଡିଆ ଦଉନି ପିଲାମାନେ ବର୍ଷେ 2 ବର୍ଷ 3 ବର୍ଷ କାଳ ଅସୁବିଧାରେ ପଡୁଛନ୍ତି they are not getting wages salary regularly that is what this the order was passed that I enclosed to my affidavit ସେଇଥିରେ ସେ ଅର୍ଡରରେ କହିଲେ ଏଟା କି ଫାଷ୍ଟ annexure B by 2 ଟା ଦେଖ got it man
yes
in pursuance of discussion with the Commissioner cum Secretary to the Governor of Orissa and order passed by the Vice Chancellor on 15/21 and ratified by the syndicate on such and such, the staff of the Population Research Center are temporary and ex-cadre employees of the university. Their salary may be drawn and disbursed by the Comptroller of Finance, Utkal University regularly every month, allowing other staffs of this university, like other staffs of the, along with other staffs of the university. The benefits seem like CPF, gratuity, LTC, medical allowance, leave encashment, etc. are also allowed to them as per the order of the administrator communicated with the letter such as GPF pension scheme will not be applicable to them. So one part is made clear, they are not entitled to pension or GPF. That is not. Why it has happened, my lord, then also I inquired. Why it is happening? The fact remains the amount is being paid by ministry, Ministry, Government of India. These people requested, the university also requested to the Government of Union of India whether pension can be paid or not. The Union of India denied. No, pension, we cannot give the pension, we are not going to give pension. Only grant in aid. If you are capable, give it. But fact remains, my lord, 3 types of employees are working in the university. Directly under roll, those who are appointed under the university. Few of them are coming under deputation and others matters under the scheme. स्कीम रे जो मान रोचन दी प्रकार स्कीम अछि गोटे आजिकल जो सेल्फ फाइनेंसिंग स्कीम मारछि ता देरे सेडा के यूनिवर्सिटी अपॉइंटमेंट होनी जे स्कीम रो प्रोफेसर के हेड जेथियो से तंकर अपॉइंटमेंट करछन्ती गेस्ट लेक्चर को डाकुछन्ती गेस्ट लेक्चर को डाकी पैसा दोछन्ती पॉपुलेशन रिसर्च स्कीम एवडा सब कोन होछि ना गोटे बड़ बड़ स्कीम जो गवर्नमेंट ऑफ इंडिया करू कि रिजर्व बैंक करू एवडा गोटे स्कीम होछि से स्कीम रे माने कंटिन्यू करछन he was working on a population scheme their pension is not applicable one party jo makes clear very clear that they are not entitled to pension now the second part matters gratuity sorry provident fund there this they will be entitled to CPF because the administrator decided it they are entitled to CPF contribution means my humble contention whatever period he has worked that is from January 86 we quantified it whatever period he worked so far if provident fund whatever contribution has been made that has been released what my learned friend submitted that the period he has not contributed would have contributed should be paid that is not the mail I think with the humility that will not be because whatever contribution you are giving that contribution is there with interest accrued additional 5% because Hon'Ble High Court directed that will be paid to you that has been paid.
But what about the arrear salary for that period?
Arrears plus I'm coming to that. What he has done is from 93 from that is what the good chart करके भेजन होते हैं he has he joined 79 means he remained absent unauthorized absent for a pretty long time for more than 6 years approximately 6 years this period university considered and regularized some part minus EL then HPL जहाँ whatever leave encashment थिला and rest है EOL है गला EOL है लेकिन continuity in service रहे बोली ताले कौन मने तंकरो last pay drawn calculation कला बोले को सेटा को notionally calculation है कि जहाँ बोली ताको university did it then what happened in the year 1998 this proceeding was initiated he was put under suspension just after 2 months or 3 months of joining suspension I learned that the people they say that they work somewhere in NGO and all these things that is not matter else it is not with us we are now consider all these things what happened from 98 we issued the show cause but we could not conclude it though Hon'Ble High Court has said that you concluded now Hon'Ble High Court quashed it because of the fact considering the fact that he has already retired what punishment will be made to him so question is for the from 98 till 2014 he received subsistence allowance arbitrarily he received subsistence allowance
now that there is no suspension what about the suspension some order must have been passed about the suspension
no pass egala apna so cost
so there is no suspension
there is so far that particular period is concerned there is no direction how it will be treated but knows about the law unless and until it is treated obviously ebbe gote condition division Hon'Ble division bench deychon seta paper mu padichi mu dekhini decision I have not gone through this period unless and until specified this period cannot be treated ex facto as if it is a regular period
no I'll tell you one the rule so service code I mean I think it is there in pension rules or service code probably where it provides that supposing there's a suspension preceding domestic disciplinary inquiry and in the disciplinary inquiry no order has been passed with regard to that so how that period of suspension will be treated then it is the authority who has to pass an order as to how that period will be treated
here in this case authority
here what has happened here the entire thing has been quashed
not entire balance that thing is that entire proceeding has been quashed but there is no order concerning payment only payment that is limited to minus retirement benefits that's kind of usual kind of
I know
but here in
I am also conscious that I am sitting in a I'm now hearing a contempt application that also I am fully conscious
so it is a contempt proceeding only thing is that gratuity so what I requested them not requested I persuaded them you total period that period under suspension to be taken towards this calculation to draw the last paid run to decide the last paid run accordingly a last paid run they arrived at last paid run fixing it notionally
calculating the increments every year
increments को देकरी तार स्टेप स्केल रिवीजन टा तांका एटा एमाने यूजीसी स्केल रिवीजन अनुसार पाउछन एमाने स्टेट गवर्नमेंट रिवीजन की आका पे ये लागुनु आरएसपी के एमएसपी लागुनु they will be entitled to only the scheme that time to time UGC रो जो नॉर्म रो जो स्केल टा बदलुची सेही बदली पाउछन आगुर जोटा कैलकुलेशन हेतला अल्प पैसा हेतला सेटा बर्तन बढी कि तांकर जो रिवीजन टा करले लास्ट पे ड्रन टा प्राय पकापकी 2 गुण बढ़ जाता এইটা বর্তমানে হয়ে গেল 22,220 এজ অন এপ্রিল 2014, 6,000 হচ্ছে গ্রেড পে, 28,000 আমাউন্ট আসলা, তাহলে টোটাল মিশিকি পাখাপাখি 56,400 মানে ডিএ আডিশন কি 56,400 হচ্ছে। না 56,400 উপরে আমি ক্যালকুলেশন করিব গ্রাচুইটিটা, কারণ ইয়ে তাଙ୍କର ଆଉ ନାହିଁ ୟୁଏଲ୍ ନାହିଁ, ସରି ଅନୟୁଟିଲାଇଜ লিভ ନାହିଁ, କାରଣ ସେ ପିରିୟଡ ସେଠି ସେ ତାଙ୍କର ଆଡଜଷ୍ଟମେଣ୍ଟ ହେଇଯାଇଛି 5 ବର୍ଷ 6 ବର୍ଷ, এই ପିରିୟଡ ତ ଟୋଟାଲି ପ୍ରୋସିଡିଂ ଅଣ୍ଡରରେ ଥିଲେ, ସସ୍ପେନ୍ସନ ଅଣ୍ଡରରେ, ତେଣୁ ୟୁଏଲ୍ লিভ ଇଜ ନଟ୍, ଦେ ଆର୍ ନଟ୍ ଏଣ୍ଟାଇଟଲ୍ ଟୁ লিভ। ତେଣୁ ବର୍ତ୍ତମାନ ଏଠି ଯାହା ଆସିଲା ଖାଲି ଲାଷ୍ଟ ପେ ଡ୍ରନ୍ ଟାକୁ ନୋସନାଲି ଆମେ ଫିସ୍ କରିକିରି ଦେଇ ଦଉଛୁ, ଗୋଟେ କପିଟା ଖାଲି ଗୋଟେ କପି ଅଛି, ଟିକେ ଦେଖନ୍ତୁ କାଲି ସିଟ୍। ବର୍ତ୍ତମାନ ତାଙ୍କ କହିବା କଥା ହେଲା ଯେ ଯେତିକି ପିରିୟଡ ସେ କାମ କରିଛନ୍ତି, ଯୋଉ ତ କ୍ୱାଲିଫାଇଂ ପିରିୟଡ, এই ସସ୍ପେନ୍ସନ ପିରିୟଡ ଟାକୁ ଛାଡି ଦିଅନ୍ତୁ, କ୍ୱାଲିଫାଇଂ ପିରିୟଡ ଯାହା ରହିଲା সেই ଅନୁପାতে ତାକୁ ରିଭାଇଜ କରି ଯାହା ଏରିଆରେ ଆସିବ ଗ୍ରାଚୁଇଟି ଆମାଉଣ୍ଟ, that will be paid. That is the decision that will be paid gratuity amount on the basis of the last paid run arrived at nationally.
Yes.
Last to সেটা 28,000 কেতে হইছে arrived at nationally হবে। বর্তমান what my learned friend given the report, he says the whole total period salary. Then second is that had I continued there, I could have become a professor. So that salary of that particular scale, and then salary for the whole total period. Salary whole total period is not borne out of the judgment. So far retirement benefit pension is not entitled to. So far provident fund has been already, whatever account they are in your account has been already paid with accrued interest, 5% interest there in addition to 5% interest, because minors are directed to give 5% interest. Now gratuity amount has been already paid. Now this amount, after revision, whatever the amount, that gratuity amount is being calculated, and the residual amount for the qualifying period. But this the suspension period cannot be treated as a qualifying period. Minors knows that. So thing is that all that whatever is being entitled to, that will be released. That process is going on. ବର୍ତ୍ତମାନ ସେତେବେଳେ 7,000 କେତେ ହେଇଥିଲା ତାଙ୍କର ଲାଷ୍ଟ ପେ ଡ୍ରନ୍ ଟା, କାହିଁକି ନା ସେଇ ସ୍କେଲ ଟାକୁ ପୁରୁଣା ସ୍କେଲ ଟାକୁ ଧରିକି 2200 ସେ ଗଳି ଆଣିଥିଲେ, ଯେହେତୁ ରିଭିଜନ ଅଫ ସ୍କେଲ ଟାକୁ ଦେଲେ that has now reached to 54,000 ସମୱhat। ତେଣୁ 54,000 ଲାଷ୍ଟ ପେ ଡ୍ରନ୍ ବେସିସ ରେ ତାଙ୍କର କ୍ୱାଲିଫାଇଂ 11 ବର୍ଷ ନା 12 ବର୍ଷ ହଉଛି, ଯୋଉ ଗ୍ରାଚୁଇଟି ପିରିୟଡ ଟା 12 ବର୍ଷ ହଉଛି, ଯେତିକି ସ୍ଲାବ ହବ ସେତିକି ଟଙ୍କା ଦିଆ ହେଇଛି ତାକୁ ମାଇନସ କରି ତା ଦେହରେ 5% ଆଡ କରି ତାଙ୍କୁ that amount will be paid.
So you pay that amount?
I will be paying that. I already instructed them that amount is going up.
You pay that amount and file an affidavit, so that what will happen is,
yes, my lord, kindly,
what will happen is, it may give rise to a further cause of action to him to challenge it. That
is what
he may not get that.
He may carve out the remedy. I can stand in the way.
He may not get that benefit what he's claiming in a content application, but it will give you certainly give rise to a cause of action. It would be a valid argument for him to say that you have not decided what will happen to the period under suspension.
Whatever, my lords. Then whatever university also make a stand, my lord, there that you were gainfully engaged during that period. All these will be adjudicated there. My lord, here in this case, I undertake this amount will be paid. I talked with my officers, my controller of finance. It will be paid within 15 days.
Yes, what were you saying?
My lord, my learned senior has pointed out the judgment. My lord, may kindly see for a moment what is the judgment. My lord, we are in contempt jurisdiction. My lord, there is very limited scope. But my lord, that cannot be an excuse not to comply with the order.
No, it's not a question of non-compliance of the order.
My lord, that is what has to be seen as to whether that order has been complied with in toto or not.
So it says,
my lord,
as we have read it many times,
my lord,
that directs the Utkal University to consider the case of the petitioner for retirement benefit.
My lord, and thereafter, my lord, may kindly have
benefit of the
my lord, to consider the case. This is a positive direction. My lord, my learned senior says that it is not applicable. My lord, may kindly have.
No, he doesn't say
so. My lord, retirement pension. My lord, I'm talking about the retirement benefit. The first point that he raised was pension.
Whether if you are entitled to pension,
entitled to, if I'm not. My lord, may kindly have my rejoinder, my lord, for a moment.
What rejoinder?
The rejoinder that I have filed, my lord.
Yes.
Rejoinder?
Here, come to the point.
Yes, my lord, annexure 9 series, page 16. This is the minutes of the syndicate of Utkal University, wherein they have accepted the general proposition that was expounded. That your lordship will find at page 17, the resolution of the syndicate committee of the Population Research Center, Utkal University. The service conditions: 1. Since the Population Research Center is a fully financed by a Government of India Ministry of Health and Family Welfare, and it is the permanent in nature, all benefits enjoyed by the Utkal University employees be extended to the staff of the Population Research Center. In terms of this, your lordship may kindly see page 18. Just a moment, my lord, just a moment. My lord, this is in pursuance, this is the 31/6/2005 order. In pursuance to the order dated this period of order dated this passed by the Vice Chancellor, Shri Bipin Bihari Hota, Deputy Director, Retired, Population Research Center, is allowed for pension cum gratuity.
To opt for pension cum gratuity cum.
Yes. So this
CPF
is
scheme.
yes, my lord. So now this person has been allowed and he is getting it, your lordship. Yes, this
No,
is
read it. He is
is
allowed
allowed to opt for pension cum gratuity cum GPF scheme as admissible to.
I think it is CPF, not GPF. I think it is CPF.
No, my lord, this is because GPF, because they say that GPF will not be, but he is entitled to. Anyway, CPF is entitled to because of the other reasons. But this GPF thing is what my lord, it's in it.
I think you will have to file a further writ application.
My lord, this pensionary benefits, my lord, my lord, this is my respectful.
Let them pay whatever they want to. Now, since the entire amount has not been paid, it would be in the interest of your client to accept whatever they pay and then to file a writ application.
My lord, I am my lord for everything, but my lord, now imagine now it is 72 years old. So
that is different matter.
My lord, but he has won something and till date, my lord, is not.
No. You must understand also the limited jurisdiction of contempt.
Right, that is right, my lord, and that is why I'm saying that he is entitled to pension.
All these matters, this court cannot decide now.
My lord, because there is already a direction to that effect.
The court cannot, in a contempt jurisdiction, the court cannot hold that since you have given it to Bipin Bihari Hota, you also give it to him.
But the court has directed.
Whatever, let them first pay. I'm keeping it pending. I'm giving them 2 weeks time. You
and my lord, so far, that gratuity amount.
Whatever you want to pay. Why should I qualify?
No.
Why should I qualify?
That, my lord.
Heard in part. Sri Dayananda Mahapatra Learned Council appearing for the Utkal University submits that the pay scale of the pay of the petitioner, after taking into account the time-to-time revisions, has been notionally fixed, and the last pay drawn has been similarly arrived at. Stop. Comma, which shall form the basis for calculating the other retirement benefits, such as gratuity, etc. Stop. He further submits that the dues so calculated shall be released in favor of the petitioner along with interest of 5% as directed by this court in the writ application within let us say 10 days.
Position nahi. ଟିକେ ଅପେକ୍ଷା କରିବାକୁ ପଡେ କାରଣ ୟୁନିଭର୍ସିଟି ବର୍ତ୍ତମାନ ଯେତିକି ପଇସା ତା ୟୁନିଭର୍ସିଟି ଆସୁଥିଲା ଆପଣ ଜାଣିଛନ୍ତି ସବୁ ଗୁଡାକ ଅଲଗା ହେଇଗଲା
within 2 weeks.
2 weeks ମୁଁ ଚେଷ୍ଟା କରୁଛି
Yes, Mr. Sora, what were you saying? Yes.
Lord, I have nothing to say, my lord. The calculation that he has arrived at is against whatever is the directions of the ministry. Page 11 of my rejoinder, that 27,000. Upon the sir. My lord, may kindly say page 11. On the face of the records, my lord, the calculation that they are arriving at is wrong. So that is, I have nothing to say, my lord, because they are giving some.
Don't worry, let them pay whatever. I'm keeping it pending. Then we will see.
Me since 2 years back, my lord, and now today also they are making the submission and the rejoinder that they have filed today, the Shokas affidavit. They have stated that we'll again take more time to pay. Despite that,
more time, 10, 15 days, 12 weeks,
that cannot, that is, my lord, I'm extremely sorry, but I have an anxiety towards this client because of his age, my lord. Except for that, I've got nothing else to say. On the face of the records, this calculation that they have arrived at 56,000. On the face of the
I will see that it should be paid within 10 days. Whatever calculation I make, I will make it because he's an old man. That's all I will do.
The old man, everybody is an old man, but don't be so emotional. Don't be so emotional.
But I know that litigation doesn't happen on emotion.
If you become emotional, then I will adjourn it.
I bow down your lordship, my lord.
No, don't do that.
Whatever order your lordship passes.
No. You are arguing very well. Don't be emotional.
I bow down your lordship.
List this matter on. I'll grant you to go to date karam.
20th May.
20th May.
So grateful.
If it is made clear that if the amount as undertaken is not paid, the registrar of Utkal University shall appear in person,
and controller of finance.
And controller of finance shall appear in person and file affidavit before this court. Okay.
मतलब दे दो मतलब जस्ट कर दो
How कौन रोला? चलेगा. Weekly list का.
I'm grateful, your lordship.
Item 46.
Actually, item 46 on behalf of Mr. Raut will be taken up after vacation.
Very good. After vacation.
Item 47, my lord.
My lord, the petitioner is in custody since 7/3/2022 under section 363, 366, 372N, 376(3) of IPC and read with 4(2) and 6 of Post Act, my lord.
Notice has been served.
Yes, my lord.
Notice
My
served
lord.
on 9/1/24.
My lord, in the deposition, kindly see the deposition
The
of the
petitioner is in custody since. जल्दी जल्दी कहबे आपण कहबा पूर्व पढि सालेनी
7/3/2024
एते हिसाब करा is in custody since 7/3/2023 in connection with such and such case. It is alleged that the petitioner kidnapped the minor daughter of the victim and subsequently sexually assaulted her. So it appears that the trial has already commenced with the victim being examined as PW 2 no 1 PW 2. Copy of the deposition of the victim has been enclosed to the bail application. Considering the submissions, the materials on record, and in particular, the evidence of the victim, I am inclined to allow the prayer for bail. Let the petitioner be released. Yes.
Item 49.
49, huh? Move 48 to 49. Yes. 49.
Case under section 376 2F.
Notice JG?
No, my lord.
Notice of 16/10/2023 there was an order?
Yes, my lord. 16/10/23, my lord.
State was directed to serve through the jury. What is your instruction?
My lord, perhaps he has solved the copy in late, so notice has not yet.
All right.
The first time it is,
All right.
I think first time it is.
Then it comes a request for some time to comply with the previous order. Release this matter. Go to week Chadikar. In the week commencing
13th May.
13th May. Yes.
Item 50.
Oh, bless.
My lord, I have filed an IA. Petition is custody in
After vacation?
IA 1689/23 that became infructuous.
Yeah, I may call. You
70 kg of ganjam.
Release this matter. I dispose of कर दो.
My lord, in the meantime, my grandmother also died last week.
इसी समय को मर ग्रेट ग्रैंडमदर भी मर जाए कौन करे डिस्पोज ऑफ कर दो.
My lord.
The petitioner in custody in connection with such and such case. It is alleged that the petitioner
Started, my lord.
yes.
Trial also not.
No, I will make some observations. It is submitted that the petitioner is in custody in connection with such and such case. It is alleged that the petitioner was in possession of was transporting
My lord.
was transporting contraband ganja weighing 70
kg.
70 kgs when he was apprehended by police.
70 to 200 grams.
From the materials on record, it is seen that the contraband was seized from the exclusive and conscious possession of the petitioner. In such view of the matter, I am not inclined to allow the prayer for bail, which is therefore rejected. However, having regard to the submission that the trial has not commenced as yet, and the petitioner has been in custody for nearly
1 year and 6 months.
for nearly 1.5 years, the trial court is directed to make sincere efforts to commence and conclude the trial as early as possible. Preferably within a period of 8 months.
Item 51 for
आपण जानना एनडीपीएस केस करिना दिले आपण जानना गोटे साखी गोटे दिन चली जाए वेरी डिफिकल्ट नहीं 8 months एकदम ठीक यस
my lord, साखी अछंती मात्र that's
ଆପଣ ବସିକି ଦେଖନ୍ତୁ କହିବେ ପରେ ୟେସ୍
Alert 6 months. Only 6 months.
ସେ ଆରମ୍ଭ କରିନାହାନ୍ତି ବିଲକୁଲ ଆଉ
ଆରମ୍ଭ ହେଇନି.
ଆରମ୍ଭ କରିଥିଲେ ହେଇଥାନ୍ତା ଖବର ଛାଡ଼ ୟେସ୍ ନେକ୍ସଟ
Item 51,
ପାସ୍ ଓଭର
item 52,
ସେମ୍ ପାସ୍ ଓଭର
item 53,
Kaustav Mahanti, kindly take it over with after.
Release this matter after vacation as well.
item 54,
54 after pass over.
item 55,
No, please, Your Lordship. In this remand case, my lord, chassis has been submitted under section 457, 380 and 34 of IPC. That he's in remand custody since 20th of February 2000.
He was taken on remand.
Yes, my lord.
What is the allegation?
Allegations that when the informant is not at his home, some miscreants barged into his house and stolen some property.
Some valuables, household implement. So how was he? This was an unknown affair.
Unknown affair. So CCTV footage is there, madam. On that basis, some accused persons they were apprehended. And mobile camera, gas cylinder, it was seized from the present petitioner.
And he has 36 criminal antecedents.
46 out of 36, madam, one is 302.
Lord, in none of the cases he has been convicted, and out of 36 cases, in 19 cases he has been acquittal has been made. And Lord, he has been taken into remand on the basis of confidential statement of the accused person.
Is it so?
Madam, 302 is there, madam.
No, is it so? 302 is all right, that can be taken care of, but is his implication on the basis of statement of co-accused?
And in this case,
in his own statement, Lord.
On the basis of his own statement. What about the CCTV footage?
Other cases, madam, CCTV footage, madam, rejection order mandate. That is, IO has verified the CCTV footage.
We will impose stringent condition of
39 and 36.
I will record that and I will impose very stringent condition. The petitioner is in custody since?
Since remand custody since 20th February 2022.
22-23. 2023.
22
to 2023. In connection to such and such case, he was remanded while in custody in connection with another case. The prosecution case is that one Jyoti Mishra lodged a FIR that Jyoti Ranjan Mishra lodged a FIR alleging that some unknown culprits broke into his house and took away valuable household equipments, mobile phones and money when he was absent. Stuff. It is submitted that no one was named in the affair and some persons were apprehended on the basis of CCTV footage. The petitioner appears to have been apprehended entirely on his own confession. How he was in custody? How could he confess? How?
It was.
He was in custody.
Yes,
so. Why was he taken on remand? First, he must have been taken on remand. On what basis was he taken on remand?
But my lord, rejection order shows that IO has apprehended the present petitioner along with other 4 persons.
So the petitioner was also similarly apprehended along with the other 2 accused persons.
But it was not clearly stated that he was in.
The several incriminating articles were recovered from the accused persons, including the petitioner. It is submitted that the petitioner has been apprehended only on suspicion and there is no admissible evidence against him. So, Learned State Council has opposed the prayer for bail by submitting that the petitioner is a habitual offender being involved in as many as 36 cases, including one under section 302. Stop. In response, learned counsel for the petitioner submits that the petitioner has been acquitted in 19.
19.
In 19 out of 19 out of the 36 cases. And in all other cases, you are on bail.
In the case which was apprehended, he was acquitted. And that.
And other cases, 19 to 36.
The trial is going on.
You are on bail.
Yes.
And in all other cases, he is on bail.
No, that is, I'm not sure.
I don't think you are sure of anything.
No.
Insofar as this case is concerned. Pratham kale confessional statement.
No, confessional, his own statement.
Is it a confessional?
Yes, ma'am. Own, not of the court. His own statement.
Yeah, no, why are you not preparing the case? खाली मैगदेले बेल्टा मिल जिवो कौन कि प्रिपेयर करो तो give a handle, then the court will pick up. That you are not doing. Even if the court wants to give you relief, the court will not.
I'm sorry.
What you are doing? पढ़ी कितनी आसीबे नहीं मने है ना कौन लिखे 19 cases. Stop. Considering the nature of allegations and in the absence of any definite material to show the implication of the petitioner, a lenient view can be taken. Subject of course to imposition of stringent conditions, looking at the criminal antecedents of the petitioner. Stop. The bail application is therefore allowed. Let the petitioner be released. Including condition 1. He shall appear before the IAC of Kothana,
Capital PS.
Capital Police Station on every alternate day for a period of 6 months. And such fact shall be certified by the IAC to the concerned court once in a week. Step. Next. He shall appear before the court below. Court in session over the matter on each date of posting of the case, and no representation through counsel shall be allowed under any circumstances. Next, he shall not leave the territorial jurisdiction of this court, of the court below, without seeking leave. Say, think that. Yes. Item 56.
My lordship, petitioner apprehended since from 6th August.
763 is there. Notice is here.
Notice Jaishi full same. Justice Satpathy had made that direction, given that direction. State upper.
So.
Land State Council requests for some time to comply with order dated 17/10/2023. List this matter, what a week Chadikar. Huh?
In the week commencing 13th.
In the week commencing 13th June, 13th May. Yes.
7.
Please, Your Lordships. The petitioner is in custody since 27/2023, Your Lordships. The initial FIR was of an against unknown person, and later on, the offense against section 376(2)(n) and POSCO Act has been in the charge sheet has come to Lordships. I'm filing the trial has begun, and I'm filing the 164 also. Last 2 pages are the 164 of the
Trial has begun, correct?
Trial has begun.
164.
Victim examine ହେଇନି. So that 164 টা ମୁଁ ଦେଇଛି copy ଟା. Last 2 pages are those. Victim has till date not yet been examined.
Victim examine ହେଇଯାଉ.
She is not supported in the 164. She has said that she had love interest. There is no, the 164 does not whisper about sexual assault as well.
Because of
376 allegation is not there. 376 allegation is not there.
Yes.
160.
164 section. The petitioner is in custody since
27, 2023.
Korea. 27, 2023 in connection with such and such case. It is alleged that the petitioner kidnapped the minor daughter of the informant and took her away to some place. In course of investigation, it was alleged that the petitioner had also sexually assaulted the victim. Perusal of the statement of the victim recorded under section 164 of CRPC, however, discloses that she has not made any allegation whatsoever of any sexual assault having been any sexual offense having been committed against her by the petitioner. Rather, she appears to have eloped with the petitioner on her own volition. Considering the above, as also the period of detention and custody, I am inclined to allow the each the appearance in the court. Yeah.
58. 1 week after one.
1 week after.
Item 59.
Pass over.
Item 60.
May I please? Whatever the 376(2) and 644, the petitioner is inside custody since 13/7/2023, my lord. And charge sheet has been filed on 30/8/2023. 164 statement, Lordship has called for.
It is called for?
Yes. 164 along with CD.
Yes.
Notice was served on 14/3.
That has already noted.
And 164 is there.
Initially 363 day FIR. One 61 daga tick kya receiver.
I mean, this is that variance from the 161.
They had got a relationship, but
the petitioner is in custody since?
Custody since, my lord, 13/7/2023.
13/7/2023. In connection with such and such case, it is alleged that the petitioner kidnapped the victim and took her away, took her to some unknown place. In course of investigation, it was revealed that the petitioner, they want to come in contact. Why should the court stop them?
Item 61. May 302. 4 of the which and here. If Lordship going through the 161 statement.
What's here? Case diary?
Independent witness matter. One Udula Malik matter.
What is the allegation? Let us see.
Allegation matter, they dragged the deceased from her house and assaulted by giving fist and kick blow. And
In this case, my lords, I have given the ECIR of the department, which is on record.
Wait, Yours. Here, my lord, the case, my lord, owes origin to that NDPS case, where petitioners and 3 others, they were taken to custody. Earlier, my lord, in a particular case, after that, they were also taken, after the order was passed, or the release order was passed, they were taken to custody in second case. Now, my lord, while they were in custody, this present case has been initiated. My lord, if the case will be accepted as it is, my lord, I think my lord and senior friend must have given the records. My lord, basing upon the application of Assistant Director ED, a criminal miscase was registered in the Court of Special Judge CBI Orissa, my lord. Court of Session Judge come. Special Judge.
Before we go for the Money Laundering Act, is it PMLA Act? Is it a predicate offense? Schedule offense? NDPS Act?
My lord, they have said so.
No, I don't know. I will have to see the schedule.
Schedule 1, my lord.
Have you checked up?
My lord.
Can you somehow have missed it?
Schedule 1.
Schedule 1?
My lord.
It seems like
NTPS is a predicate offense, but money laundering is not a predicate offense.
No. Money laundering is the main.
Predicate offense. Money laundering is a special act.
Offense is under paragraph 2 of the schedule. All right. Schedule part A, paragraph 2.
My lord. Yes. So, while they were in custody, an application was filed by the authorities, my lord, to, my lord, records have been given, my lord, An application was filed under Section 50 of PMLA Act 2002 by Assistant Director ED, Orissa through advocate, along with memo of appearance and so on. So, peruse the same, that application was filed, and basing upon that application, when the offense, whether it is coming under the, if the person concerned who is taken under money laundering, then the basis is predicate offense or a little offense, they should be arrested first, then a remand order will be passed as per the statute. My lord, here on 27.
I could not follow. Please, can you please repeat?
My lord, they say if it is a Madam, may see it by my lord.
You have a copy?
Xerox copy of it. Certified copy. I will give it on ma'am. Yes,
3/5/2023.
My lord.
Yes.
This order, my lord, has been passed by the Learned Sessions Judge, Khurda.
Oh, paying for remand.
Paying for remand.
Yes.
My lord, may see the order. Learned Special PP for ED contended that the accused persons have been arrested in Sahadev Hunta PS case number 352 of dated 27/10/2022 for commission of offence under 21C29 of NDPS Act for possessing 10.394 kgs of brown sugar amounting to rupees 10 crores 39 lakhs 40,000 and are inside judicial custody for District Jail, Baleshwar. He further contended that the said accused persons have also been booked under Section 3 of PML Act for committing the civil offence, coming under 21C/29 of NDPS Act. In support of his contention, he has filed Xerox copy of ECIR dated 14/11/2022 to show that the proceeding has been initiated against the said accused persons along with others for commission of the offence under section 3 of PMLA Act, punishable under section 4 of the said Act, and placing reliance on the decision of the Hon'Ble Apex Court in Vijay Madanlal Chaudhary versus and others versus Union of India into 2022 SEC Online 629 para 467, wherein the Hon'Ble Apex Court have observed that so and so in view of the special mechanism envisaged by the Act, ECIR cannot be equated with FIR under the 1973 code. ECIR is an internal document of the ED, and the fact that FIR in respect of the schedule offence has not been recorded does not come in the way of authorities referred to in section 48 to commence inquiry stroke investigation for initiating civil action of provisional attachment of property being proceeds of the crime. Supply of a copy of ECIR in every case to the person concerned is not mandatory. It is enough if ED at the time of arrest discloses the grounds of such arrest. But let me take note of it.
Yes.
However, when the arrested person is produced before the special court, it is open to the special court to look into the relevant records presented by the authorized representatives of ED for answering the issue of need for his stroke her continued detention in connection with the offence of money laundering. To maintain confidentiality, did not file the complete ECIR on the above submission prayed to allow the petition. Peruse the case record from the copy of the ECIR dated 4/11/2022. It is apparent that ED has initiated the said proceeding against the above named accused persons in this case, resulting from the predicate offence under section 21C and 29 of NDPS Act, which is serious in nature, engulfing the youths at large. The contention advanced by the Lord and Special Public Prosecutor for ED requiring custodial interrogation of the said accused person is not without force, as the source of and root of the alleged crime need to be unearthed. Keeping in view the above facts, submissions, the prayer of the Lord and Special PP is allowed. So the application was allowed, and they were shown to be taken to custody or remanded on 8/6/2023. Next order, valid. They have been taken to custody. And since 8/6/2023, we are in custody. The fact remains valid in the present case. My lord, if my lord will see the first annexure, the complete petition.
Is it after you were arrested again? But in the other case?
Yes.
You were arrested at the
Second
jail
case.
gate. In the second case.
My lord.
In which
Then
I have
in the second
directed
case.
in which I have directed you to be released on bail.
My lord.
This is after that.
After.
No, I'm okay. 8/6/2023.
8/6.
I have passed the bail order very recently.
No, this case is my lord was pleased to pass the order.
Very recently I have passed that order.
15-20 days. That is my lord on 16th April 2024.
All right, but
this is second case.
সেই কেসের আরেস্ট কেবে হইতলে?
এই কেসে আরেস্ট হইছিল আমি
আপন বাহারিলা পরে আরেস্ট হলে না? জেল গেট রে আরেস্ট হলে? So when is that date?
এই কেসে আরেস্ট হইল 27/5/2023.
Yes, 27/5 রে.
My lord.
So when you were in custody, when this case was pending, this remand has been taken.
On 8/6. 27/5 বেଳକୁ ଆମେ କଷ୍ଟଡିରେ ଥିଲୁ.
Again, in that second case being rearrested.
My lord.
Rearrest মানে rearrest.
This jail guest ଦେଇଗଲେ. While we are in custody, this ED case.
Yes.
My lord, may see the complaint petition which they had filed before the Lawrence Sessions Judge cum special judge.
That is here.
Yes, at my bail application, page 6.
Yes.
Seven persons have been named in the complaint petition. But I got it at page 8.
Yes.
7 persons, six persons and 7 others. Wherein they have stated about the case where petitioners and others were taken to custody under NDPS Act, my lord. My lord, one thing my lord can mark that in the NDPS case, my lord, around 6 persons were there. Here, my lord, petitioners are 2 in number, those who have been booked under ED. There, my lord, 6 persons were arrested in the first case and the second case. In total, 6 persons. And their allegation is that we are in possession of 10 cases, some odd brown sugar, which were seized for the spot. But in the first case, my lord was pleased to release them on bail because they were not produced within 24 hours. And the second case, my lord, there was no allegation whatsoever. They have picked up 2 witnesses after some pretty more days, and those witnesses have also not stated anything against the petitioners, for which they were released on bail. My lord, the reasons best known to them, my lord, why they decided to leave this other 3 persons and put these 2 persons on the ED case, my lord. My lord, fact that in the second complaint, which was filed after taking us to remand, that is on, petition was filed on 4/8 at page 13, my lord.
Another complaint.
Another complaint. After the remand was allowed, that took us in remand, and application was filed, complaint petition was filed under section 45, reduce section 44 of the Money Laundering Act. And it got it?
Yes.
Which was registered number as complaint case PMLA number 6 of 2023.
Yes.
Well, I just want to draw my lord's kind attention to this, because on a reading of the entire complaint petition, my lord may kindly see paragraph 3.3.
3.3.
3.3. They have given a chart. Name of the accused persons, name and address of the accused persons, so and so, so and so, so and so, search survey. Like this ballot, they are continuing. Yes, sir. What I want to show, my lord, they are making allegation. There are around 10 crores some odd sale proceeds are there with the petitioners, forgetting the fact that these 10 cases of brown sugar, which was alleged that the petitioners were in possession, petitioners and others were in possession, that was seized at the very spot itself. Nothing is there. Nothing was there at this time, my lord. And not a single property has been shown to have been in possession of the present petitioners, or any bank account or anything. Rather, they have come forward with a case relying upon the charge sheet of the NDPS Act, that the money which was the sale proceeds of these illegal drug transactions, that has been dealt through Howla. That is not there. That is not there. These persons, those who have not dealt in Howla, 2 persons, they have not been taken as an accused here. They say they could know that the money, they could not get anything from the petitioners or their private property or any transactions. Inquiry has been completed. Ultimately, my lord, special judge was pleased to take cognizance of the offence. My lord may kindly see on on 7/8/2023. Then order sheet, my lord may see 7/8/2023.
Yes.
Investigation was completed. My lord will see from the complaint petition, nothing is there. No, not a single ₹1 has been shown that this is in my account or the thing, anything is there in my account. Ultimately, they said, relying upon number of provisions only to make a confusion, that this provision has not been taken note of, this provision has not been taken off, section 71, notwithstanding anything contained in CRPC will not be taken off, this, that. One thing I want to draw my lord's kind attention, my lord may kindly see section 19 of the Act. Out of many provisions which they have taken note of, I am relying upon section 19, power to arrest. If the director, deputy director, assistant director, or any other officer authorized in this behalf by the central government by general or special order has on the basis of material in his possession reason to believe, within bracket, that reasons for such belief to be recorded in writing. My lord, we kindly take note of this, my lord, that any person has been guilty of an offence punishable under this Act, he may arrest such person and shall, as soon as may be, inform him of the grounds for such arrest. The director, deputy director, assistant director, or any other officer shall, immediately after arrest of such person, under subsection 1, forwarded a copy of the order along with the materials in his possession, referred to it in that subsection to the adjudicating authority in a sealed envelope in the manner as may be prescribed, and such adjudicating authority shall keep such order and material for such a period as may be prescribed. Every person arrested under subsection 1 shall within 24 hours be taken to a special court or judicial magistrate or metropolitan magistrate, as the case may be, having jurisdiction, provided that the period of 24 hours, that is not required, my lord.
Yes.
My lord, this section 19 has been construed by the Honorable Apex Court in a recent judgment, that is by Lord Pankaj Banshal. ଆପଣଙ୍କୁ ଦେଖେଇଦେବେ ନା ଆପଣ କାହିଁ କରିବେ ଆପଣ ମାଷ୍ଟର ଏଥିରେ ଆମେ ଆପଣଙ୍କୁ କେସ୍ କରିବାକୁ ବସିଛୁ. That is by law also reported in 2024 volume 93 OCR, Supreme Court page 57. This provision has been taken on, my lord may kindly see paragraph 8. I'm just drawing the relevant portions of the paragraph wherein the Honorable Apex Court, considering a situation of this type, the arrest is illegal, everything goes with it, all consequential things. My lord may see, read down and
yes,
read into. My lord, got it?
Yes, yes.
Read down and stroke or read into, as well as the expound, deliberate upon, and delineate the ambit, sweep, and scope of section 19(1) of the PMLA in consonance with the principles inter alia enunciated by the Honorable Supreme Court in Bijan Madanlal Chaudhary versus Union of India, that is reported in my lord 2022 SCC online, as well as my lord 2022 10 SCC scale 577.
Yes.
My lord, the expression material in possession occurring therein must be confined, circumscribed, and limited to legally admissible evidence of sterling quality and unimpeachable character, on the basis whereof reasons to believe would be recorded in writing that the arrestee is guilty. Well, this is very, very important. Court is to reach at a conclusion the arrestee is guilty. Is not an accused. He is to be punished, guilty of the offence under section 4 of the Act. The word guilt occurring therein, the word guilt occurring therein would qualify a higher yardstick than a mere suspicion. And Law and Court at the stage of remand is required to apply its mind to the grounds as well as necessity for arrest as inter alia held in Ernest Kumar versus State of Bihar, 2014, volume 8, SCC 273, and as accorded imprimatur in Satyendra Kumar Antil versus CBI, 2022, SCC online 825. 3. The expression communicate occurring therein would definitely entail physical communication and furnishing the grounds of arrest to the arrestee in the context of the obligation for reasons for such belief to be recorded in writing. It is read with rules 21G and 21H of PMLA rules, my lord, 2005, arrest rules, my lord, which postulates the meaning of the word order to include the grounds of such arrest. My lord, paragraph 9, third line, my lord. Further, the remand orders were passed in patently routine and mechanical manner by the learned vacation judge stroke additional sessions judge Panchkula without satisfying himself in that particular case, my lord, Pankaj Bansal and his brother. Panchkula, without satisfying himself about due compliance with the mandate of Section 19 of the Act 2002, and more particularly, whether the threshold requirements of the provisions were duly satisfied. In consequence, they prayed for a direction to quash the remand order as well as the underlying arrest orders and arrest memos. Paragraph 10, my lord. Though the appellants did not challenge the constitutional validity of Section 19 of the Act 2002 in their writ petitions and had only sought reading down and or reading into the provisions thereof in the light of the judgment of this court in Vijay Madanlal Chaudhary and others versus Union of India, the division bench of the Punjab and Haryana High Court failed to note the distinction and disallowed. That is, in that particular case, Punjab and Haryana High Court had not taken note of the petition which was filed by the accused therein, and they thought that validity of that act or ultravirus of the act has been challenged, but that was not there, madam. Well, let me see at this juncture, paragraph 16. Yes. In terms of Section 19(3) of the Act of 2002 and the law laid down in the above decisions, Section 167 CRPC would necessarily have to be complied with once an arrest is made under Section 19 of the Act 2002. The court seized of the exercise under Section 167 CRPC of remanding the person arrested by the ED under 19(1) of the Act 2002 has a duty to verify and ensure that the conditions in Section 19 are duly satisfied and that the arrest is valid and lawful. In the event the courts fail to discharge his duty in right earnest and with the proper perspective, as pointed out there herein before, the order of remand would have to fail on the grounds, and the same cannot by any stretch of imagination validate an unlawful arrest made under Section 19 of the Act. 17. My lord, in the matter of Madhu Limais and others, 1969, 1 SCC, so and so, was 3 judge bench decision of this court, wherein it was observed, it was observed that it would be necessary for the state to establish that at the stage of remand, the magistrate directed detention in jail custody after applying his mind to all relevant matters. And if the arrest suffered on the ground of violation of Article 22(1) of the Constitution, the order of remand would not cure the constitutional infirmities attaching to such arrest. Viewed in this context, next paragraph, my lord, the remand order dated 15/6/2003 passed by the learned vacation judge stroke additional sessions judge Panchkula reflects total failure on the part of in discharging his duty as per expected standard. The learned judge did not even record a finding that he perused the grounds of arrest to ascertain whether the ED had recorded reasons to believe that the appellants were guilty of an offense under the Act 2002. At this juncture, my lord, we see the remand order. For that reason, I had drawn my attention to the remand order. Well, let me kindly see. Order dated 3/5/2023. Wherein, my lord, these conditions have been fulfilled. Or not.
Yes.
My lord, here only, like the present one, like the, my lord, this remand order, my lord, we'll see the last page. Peruse the case record from the copy of the ECR so and so. It is apparent that the ED has initiated the said proceeding against the above named accused persons in this case, resulting from the predicate offense under section so and so, which is serious in nature, engulfing the youths at large. The contention advanced by the special PP for ED requiring custodial interrogation of the said accused person is not without force, as the source and root of the alleged crime need to be unearthed. Well, let me see the judgment. I'm just going to that one. The London judge did not even record a finding that he perused the grounds of arrest to ascertain whether the ED had recorded reasons to believe that the appellants were guilty of an offense under the Act 2002 and that there was proper compliance with the mandate of Section 19 of the Act 2002. He merely states that keeping in view the seriousness of the offences at the stage of investigation, he was convinced that custodial interrogation of the accused persons was required in the present case and remanded them to the custody of the ED. Same matter, same custodial interrogation, the case is serious, so ED is necessary. The sentence, it is further that, within quotation mark, all the necessary mandates of law have been complied with follows. It is the case of the prosecution and appears to be a continuation thereof as indicated by the word further and is not a recording by the learned judge of his own satisfaction to that effect. That was contended by PP and he accepted it and remand order was passed. Well, that has been both further construed by the Honorable Apex Court at paragraph 28. 28, madam. No doubt, in Vijay Madanlal Chaudhary, this court held the non-supply of ECR, but after that also. ECIR in a given case cannot be found fault with. Here also, ECIR has not been given. I'm not pressing hard because they say it's not mandatory. As the ECIR may contain details of the materials in the ED possession, and revealing the same may have also deleterious impact of the final outcome of the investigation or inquiry. Having held so, this court affirmed that so long as the person is informed of the grounds of his arrest, that would be sufficient. Here, but there is no document to show that we have been informed earlier to the remand order that you have been taken to custody or you have been you are required in PMLA Act. But paragraph 29. In this regard, we may note that Article 22(1) of the Constitution provides, inter alia, that no person who is arrested shall be detained in custody without being informed as soon as may be on the grounds for such arrest. This being the fundamental right guaranteed to the arrested person. The mode of conveying information of the grounds of arrest must necessarily be meaningful so as to serve the intended purpose. It may be noted that Section 45 of the Act 2022, and Section 45 is like our Section 37 of NDPS Act, enables the person arrested under Section 19 thereof to seek release on bail, but it postulates that unless the twin conditions prescribed thereunder are satisfied, such a person would not be entitled to grant bail. The twin conditions set out in the provisions are that first, the court must be satisfied after giving an opportunity to the public prosecutor to oppose the application for release that there are reasonable grounds to believe that the arrested person is not guilty of the offense, and secondly, that he is not likely to commit any offense while on bail. To meet this requirement, it would be essential for the arrested persons to be aware on the grounds on which the authorized officer arrested him or her under section 19 on the basis of the officer's reasons to believe that he or stroke C is guilty of an offense punishable under the Act of 2002. It is only if the, this is very, very important, my lord. It is only if the arrested person has knowledge of these facts, he or she would be in a position to plead and prove before special court that there are no, guilt, the grounds to believe that he or she is not guilty of such offense so as to avail the relief of bail. Therefore, communication of the grounds of arrest as mandated by Article 22(1) of the Constitution and Section 19 of the Act 2002 is meant to serve this higher purpose and must be given due importance. 30. And we may also note that the language of Section 19 of the Act 2002 puts it beyond doubt that the authorized officer has to record in writing the reasons for forming the belief that the persons proposed to be arrested is guilty of an offense punishable under the Act 2002. Section 19(2) requires the authorized officer to forward a copy of the arrest order along with the material in his possession referred to in Section 19(1) to the adjudicating authority in a sealed envelope. Though it is not necessary for the arrested persons to be supplied with all the materials that is forwarded to the adjudicating authority under Section 19(2), he or she has a constitutional and statutory right to be informed of the grounds of arrest, which are compulsorily recorded in writing by the authorized officer in keeping with the mandate of Section 19(1) of the Act 2002. It's not there in the complaint petition. No record, nothing is there that we have intimated this, that. As already noted herein before, it seems that the mode of informing this to the persons arrested is left to the option of ED's authorized officer in different parts of the country. That is to either furnish such grounds of arrest in writing or to allow such grounds to be read by the arrested persons to be read over and explained to such persons. Paragraph 32 is more important, my lord. That being, but here, my lord, they have quoted, Honorable Apex Court has quoted Rule 6 of the Prevention of Money Laundering, the principle of arrest. But this is important, usually not available in the books, my lord. That part, Rule 6 of the Prevention of Money Laundering, the forms and manner of forwarding copy of order of arrest of a person along with the materials to be adjudicating authority and its period of retention, Rules 2005. Title forms of records provided to the effect that the arresting officer, while exercising power under 19(1) of the Act 2002, shall sign the arrest order in Form 3 appended to those rules. Form 3 being the prescribed format of the arrest order reads as follows. So and so, so and so. My lord, paragraph 32. That being so, there is no valid reason as to why a copy of such written grounds of arrest should not be furnished to the arrested person as a matter of course and without exception. There are two primary reasons as to why this should be in advisable course of action to be followed as a matter of principle. Firstly, in the event such grounds of arrest are orally read out to the arrested persons or read by such persons with nothing further, and this fact is disputed in a given case, it may boil down to the word of arrested persons against the word of the authorized officer as to whether or not there is due and proper compliance in this regard. The case on hand, that is the situation insofar as Bansal is concerned, though the ED claims that witnesses were present and certified that the grounds of arrest were read out and explained to him in Hindi, that is neither here nor there, as he did not sign the document. Non-compliance in this regard would entail a release of the arrested person straight away, as held in V. Senthil Balaji. Such a precarious situation is easily avoided and the consequence thereof can be obviated very simply by furnishing the written grounds of arrest as recorded by the authorized officer in terms of Section 19(1) of the Act 2002 to the arrested persons under due acknowledgement instead of leaving it to the debatable said dedicate authorized official. The second reason as to why this should be the proper course to adopt is the constitutional objective underlying such information being given to the arrested persons. Conveyance of this information is not only to apprise the arrested persons of why he is being arrested, but also to enable such persons to seek legal recourse and thereafter present a case before the court under section 45 to seek release on bail. If she so chooses, if he or she chooses, in this regard, the grounds of arrest, B. Senthil Balaji, are placed on record, and we find that the same run into as many as 6 pages. The grounds of arrest recorded in the case on hand in relation to so and so, that is on merit, my lord. Here, my lord, taking note in paragraph 35 on the above analysis to give true meaning and purpose to the constitutional and statutory mandate of section 19(1) of the Act of 2002 of informing the arrested persons of the grounds of arrest, we hold that it would be necessary henceforth that a copy of such written grounds of arrest is furnished to the arrested persons as a matter of course and without exception. The decision of the decisions of 2 high courts that are contrary to each other do not lay at the grounds for correct law. In the case on hand, the admitted position is that it is investigating officer merely read out or permitted reading of the grounds of arrest of the appellant and left at that stage, which is also disputed by the appellant, as this form of communication is not found to be adequate to fulfill the compliance of section Article 22(1) of the Constitution of India, Constitution, and section 19(1) of the Act. We have no hesitation in holding their arrest was not in the provisions of 19(1) of the Act. Accordingly, my lord, they released, my lord. Here, my lord, I have drawn my lord's attention to the complaint petition, to the second complaint under Annexure 2. And I have drawn my lord's attention that while they were in custody in other 2 cases, this has been communicated. Sorry, the prayer has been made by the detaining authority, so to say. I can say, my lord, they term them as the detaining enforcement officer, detaining authority to pass a detention order. Accordingly, order was passed by the London Special Judge. But the order is cryptically silent, my lord, and is not in the line of section 19(1), 2, 3 of the Act. Here also, my lord, if my lord will see the purport, what is the purport of this Act, my lord? The purport of the Act is to curtail, my lord, these illegal transactions of money. Yes, my lord, the petitioners have been taken as an accused. It has not yet been proved that they are guilty of the offences, but they have been taken as an accused. They have been charged. But the fact that the articles which they was there in possession that was seized at the spot, these 10 kgs which has weighed in the mind of the ED people, that why it has been sold and 10 crores have been income has been earned in that way. Ballot will see they have given the amount 10 crores. I don't know from which source they got this amount 10 crores, 39 lakhs and something odd. It has been mentioned in the case, but not a single material has been seized to show that even 1 rupee has been seized. Rather, they have, my second complaint, my lord, which is an exhaustive one, my lord will see. Any line is there, my lord, they have given an explanation with regards to the earlier case of NDPS Act in detail, and all names of all the accused persons, and they are rather they have stated, my lord, that some accused persons are having beetle shop, some having grocery shop, and some are stationery shop like this. And ultimately, they have reached a conclusion that 10 crores and money has been transferred through Howla. Nothing they could get for which the Howla is has been taken resort to. My lord, we will see last. Accordingly, the Honorable Court may be pleased to take cognizance, and accordingly, cognizance has been taken. And my lord, for this case, I'm taking into consideration the earlier custody. This custody, my lord, if we have been remanded on 8/6/2023 until the date we are in custody.
Then we'll continue tomorrow.
Yes, my lords, we'll continue tomorrow. But may I only mention for 2 minutes?
Yes, yes.
What my learned friend has stated, with great respect to my learned friend and his senior gown.
What senior gown?
No, why?
You're 20 years senior to me.
No, you're senior. It is neither fish nor flesh, but a bunch of trash. Why I say so? I take my lordship to section 50. Straight away, I take my lordship to section 50.
50 of the PMLA Act.
PMLA Act. Subclause 2.
Yes.
Power of the authorities regarding summons, production of documents, and to give evidence. The director shall, or purposes of section 12, for having the same powers vested by the civil court under the Code of Civil Procedure, so and so, while trying a suit in respect of the following: discovery, inspection, enforcement, and attendance of the person, compelling production of record, receiving evidence on affidavit, issuing commission for examination of witnesses and documents, or any other matter which may be prescribed. 2. The director, additional director, joint director, deputy director, assistant director shall have power to summon any person whose attendance he considers necessary, whether to give evidence or to produce any record during the course of investigation or proceeding under this Act. All such persons summoned shall be bound to attend in person through the authorized agents, and such officers may direct shall be bound to state the truth upon any subject respecting which they shall be explained, the man making statement, the production of documents as may be required. Every proceeding under this subsection 2 and 3 shall be deemed to be a judicial proceeding within the meaning of section 193 and 228 of the Indian Penal Code. Subject to any rules on this behalf, the central government may, any officer referring to subsection may impound, retain, and so in custody as it thinks fit any records produced by him or the procedures under this Act. Now, my humble contention, when they called upon a summons, well, this being a generic act, being a special act by its own nature, a complaint is only filed. With great respect, I must say, come to 19, my lords. He was trying to say that has, on the basis of material on record, he was pressing upon 19 on the basis of material on record. He stated there is no material on record. I will, it is before my lordship, which my lordship would see, and I have given my copy, that he has got innumerable bank accounts under operation, resorting to Hawala, which they themselves have confessed. It was explained to him that any statement you make herein will go against you by the authorized officer. He understood it and stated, not only me, my whole family, my wife, my brother, my father, my sister, my cousins, including going down to Goa, who is the head of the organization, and to Nepal, have been doing this Hawala business and resorting to NDPS. Innumerable cases which has been filed against us, which my lordship would give my copy. I will read it out to my lordships, and then my lordship may proceed, and I will continue my argument. Yeah.
So you start with the contention that section 19 has been complied with.
Not only complied with, if I bring it to my lordship's statement, which is a judicial proceeding, all that we do under section 50 subclause 2, because he signs it, it is explained to him as a piece of evidence under the Evidence Act. We take it and place it at the time of trial saying this is evidence, exhibited, marked against him, and then the opponent will examine the witness designated. Now, my lordship sees, I will only read out 3-4 portions of the 3-4 portions, my lords. Rintu Tarai, so-and-so, 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 the special judge under so-and-so, Bhubaneswar, 52, subclause 53 of the PMLA Act. The assistant director made a statement requiring to be recorded in so-and-so, so-and-so. I was explained that the proceeding under section 50, subclause 2, 50, subclause 3 of the Prevention of Money Laundering is a judicial proceeding within the meaning of 193 and 228 of the IPC. I was made to understand that during this proceeding, I have to state the truth, and if the statement given by me or any part of this proves to be false in future, I will be liable for actions under the Indian Penal Code. I was also informed that my statement would be used against me, anyone else, as a piece of evidence in any legal proceeding. Keeping these provisions in mind, I give my following statements.
But that is under section 50.
50 subclause 2 and 3.
That is on a different aspect, I believe. This is my prima facie view. Section 19 requires...
19 relating to arrest.
Arrest, yes.
But he stated that there was no material and one sec. Did I disturb you? One sec. My lordship sees, I have given a copy to my lordship. My lordship will find it on the next date. There are, first, I know I have bank accounts relating to bank number, ICICI Bank, State Bank of India, Union Cooperative Bank.
Sir, you see, this act comes into picture as an offshoot of a predicate offense. The money, the proceeds of crime, which that crime means out of the predicate offense. That has been offense.
Correct.
That has been laundered.
I will explain.
I will use the word laundered. Laundered means hawala.
He says I've done hawala. He says.
I would like you to please point out tomorrow. You have come up with a specific amount. 10 crore, 29 lakhs, so on so forth.
Yes. He himself had stated.
Whatever. I don't know. I don't know.
I need 2 minutes. 2 minutes of my lordships would bear with me. Since when have you been engaged in illegal business of distribution and consumption of narcotics? I've started business illegal distribution, consumption of narcotics and such other since 1916 to 17. And I've been continuously dealing with one Rafiq, one so-and-so, 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 Balasore, and sell them in small packages, so-and-so. He is my son, my father-in-law, my wife, Minoti Tore, and she is converted in Hindu, my father-in-law, S.K. Jufar, Jamad, so-and-so, 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 so-and-so. Then my lordship sees what is very, very important. S.K. Raju, a native of Balasore, is a kingpin of brown sugar. As far as I know, he is residing in Goa. He is running the hotel in Goa. And the details, he said, pawn shop. And some other known to me. Raju is having a wide network all over India. S.K. Raju is also arrested and released on bail in drugs so-and-so. And also detained in brown sugar. I used to purchase 25-30 grams, about 4,000 rupees per 5 grams, and then use them into small packets. To the inquiry, 5 grams. I use them in 50 small packets. At 200, 300, I have deposited each cash to Rasik, who is resorting to Hawala, then so-and-so. Then he says, my lords, I met Rakesh Kumar, so-and-so. He was arrested in the instance case, came as a messenger with me, and he recovered a mobile phone of Abu regarding money laundering and transferring money. He also told me of handling Hawala and operating of Hawala and other engagement in the business of illegal sale of narcotic drugs and etc. in Odisha. Then I have innumerable accounts which I have quoted here, a lot of accounts. Then he says, I used to hand over the proceeds of the illegal narcotic substance to Sahabu and his uncle Rafiq in cash. And likewise, and his family members, Sabu has shifted to Bali in the villa of so-and-so and so-and-so. And the family and the extended family of Sabu is engaged in illegal trade of narcotics. Everything was recorded. Then these things were placed. Now my lordship would see page annex 44, section 44, subclause 3. I will first mention it, my lord, then my lordship would see it when I continue, my lords. Taking these proceeds and this evidence under 50, we take this evidence and place it before the special judge, district judge Bhubaneswar. He looks into the proceeds and the designated officer, the director, deputy director, assistant director, whoever may be, being present, places his records in a closed envelope. He opens, the district judge, special judge opens it, looks into the records, and then takes cognizance of the offence. The accused need not be present at that time, and an FIR cannot be equated with a complaint filed as per the definition. Investigation initiated under PMLA Act is totally different there. Under section 48A, 1A, a police officer cannot investigate into an offence by the statute, and under 45, unless two conditions are satisfied. One, he is not likely to commit the offence. 45. I will just place the exact words. Exact words. Where the so-and-so. And the reasonable grounds of believing that he is guilty of the offence. What has the district judge got to do? After seeing this evidence on record, made by him under 50 subclause 2 on affidavit, and that being a judicial proceeding, if he is satisfied there is reasonable ground to believe that he is guilty of the offence,
he is not guilty
and is not likely to commit the offence.
He is not guilty. He is not guilty of such offence.
I'll read it. Where the public prosecutor opposes the bail application, the court is satisfied that there is a reasonable ground to believe that he is not guilty of the offence and that is not likely to commit an offence, then only he will release him on bail. With this kind of evidence, how can the district judge release him trying to keep these two conditions? This is the whole case. I will continue, my lord.
Continue tomorrow. Remaining matters tomorrow?
Tomorrow at 2 o'clock, my lords.
Obviously after 2.
Would I keep it at 2, my lords? Why? Because
it will come at 2 o'clock. In the first hour or the other supplementary list will be taken up. Other matters are there.
So, or we will keep it on Monday. Because my lordship, I wanted to satisfy my lordship. What he's saying is not correct.
All right, heard in part, list this matter.
Heard in part, let it be on Monday. Arguing it's a great pleasure to argue. We fight with all our mights, but we dine as friends. Who can say this?
So we'll take it up to the next week. Next week, commencing here, weekly list as you.
Yes. Heard in part means will come in the top.
That system is not working. That system is somehow not working, sir.
No worry. I only do my part before my lordship, and I feel it's a greatest pleasure to appear before my lordship. Openly, I would say this. I've yet to come across someone like this. By God.